Item number 36, Lordship.
36,
Lordship.
Lordship.
Lordship, in this case, Lordship, the up to the case there was
1 minute,
called-
1 minute, 1 minute. এক মিনিট এখন লৈ যাব এখন লৈ যাব লৈ যাব 36. Yes,
Lordship, up to date case there was called for, Lordship. This is not received, Lordship.
not received.
Reminder me.
Yes, Mr. Borua.
It was returned, but it was, earlier we have received the case, there was,
When it can be expected.
now we have not received the updates anymore.
So from which police station?
Posisto Mela. Posisto Mela.
Mohisto.
Can fix it on 8th of August, Monday.
Okay. Not on 8th of August, there will be 11th of August. Mr.
K Thakur Mela.
K. Thakur, Learned Constable of Petition is present, Mr. R.J. Borua. Learned Additional Public Procedure has submitted that the case diary as called for, up-to-date case diary as called for, has not been received. As sought for by Mr. Borua is the case on 11th of August for production of up-to-date case diary.
Deeply.
May I please pray for listing mala for admission. Criminal petition.
Criminal petition.
Next is need mala.
Next to-
6th of August.
Give it to the courtmaster, courtmaster will give the date.
May it please your Lordship. Lordship was allowed my 4:30 application. Lordship, we had filed it on Monday. Lordship, the main matter is listed tomorrow. May it be Lordship listed along with IA, Lordship.
IA,
Lordship, 4:30 application, Lordship.
okay.
Lordship, tomorrow, Lordship, with the main matter.
Main matter is listed when?
Tomorrow it is listed. Main. I'm deeply aware.
Yeah, please, Your Lordship. I beg to mention item number 31. Admission matter, my lord. In this case, my lord, respondent CBI filed an objection, my lord. Yesterday, we have my lord, received, my lord. This is
Respondent CBI,
Yes, Lordship.
okay.
Not on record, Lordship. So I pray for on 8, if possible, Lordship.
No, 11,
My lord, 11, some difficulty then after
Hmm?
13.
13,
13, Lordship.
okay. Mr.
Digo.
D. Gogoi, Learned Counsel for the petitioner has submitted that he has received a copy of
Objection, Lordship.
an copy of the objection filed by the CBI only yesterday.
Yes, sir.
Full stop. As the said objection is not part of the case record. He has sought listing of the case on another date. You have informed the other side?
Yes, yes.
Okay. It is submitted that consent has been taken from the Learned Counsel for the respondent CBI. Full stop. Has sought for release the case on 13/8/2025.
I know.
May I please, Your Lordship. Lordship, with the consent of the other party, I beg to mention item number 22.
22.
Yes, Lordship. The matter may be adjourned for today as the senior English counsel is.
Okay, you have informed the other side. Okay, Mr. On the prayer of Mr.
A Muhammad, Arif Muhammad.
A. Mohammed, Learned Counsel for the petitioner. The case is passed over
Lordship,
party. It is submitted that consent has been taken from the,
17, 18 maybe, any date may be fixed, Your Honor.
then after
17.
1 week. After 1 week. Possible.
May it please, Lordship.
Stands adjourned for
Also,
1
I
week.
beg to mention for listing one criminal revision petition, Lordship. This matter was in 2018 matter, Lordship, and last listed on 1st of February 2021.
Okay, give it to the courtmaster.
Master.
He'll give the date.
May I please, Your Lordship? Lordship, I beg to mention an urgent listing of a criminal revision petition against the judgment and order of the appellate court in a matter under the NI Act tomorrow, my lords. As the matter under the NI Act against the judgment and order of the
Not
appellate.
tomorrow, Monday.
No, Monday would be difficult. Tuesday then, my lords. I'm so sorry.
Tuesday will not fix anything, hearing matter. And then Wednesday.
I'm so blessed, my
Please,
lords.
Lordship, I am praying for listing of interlocutory applications for orders, my lord, and next to any date Lordship permits, my lord. Deeply obliged.
May please, Lordship. Lordship, I want to mention regarding listing of a criminal petition of 2022, Lordship. It was last listed on 23/3 of 2020.
Give it to the courtmaster.
Friday, Lordship.
Give it to the courtmaster.
May I please, Your Lordship, I beg to mention item number 6, Lordship, possible for a day. I should raise some medical issue, Lordship.
On the prayer of Mr.
RL Chutia,
R.S. Sutia, Learned Counsel for the petitioner.
next week, any date, Lordship.
How many adjournment you have made?
One day,
Huh? In motion column? You be there. I'll see.
May I please, your lordship? I beg to mention item 10. I have another matter as item 8, your lordship. So it will be very much difficult for me to manage both the courts. Be kind enough to fix at 2, your lordship.
Well, we don't, doesn't, you will come whenever you are available. After a motion, we can take.
Much obliged.
May I please, your lordship. Lordship, I beg to mention criminal revision petition for listing for orders, lordship. Okay.
May it please your lordship. My lord, I beg to mention for a listing of interlocutory application 649 of 2025, my lord. My lord, the matter was listed on 21st of July, my lord. And the matter was fixed for after a week, my lord. And PP was directed to file an objection in this matter, my lord. So, my lord, the matter has not come yet. So,
Okay,
let
give
the
it to
matter-
court
Friday,
master.
ma'am.
Give it to the court master, he'll give it it.
my lord.
Please, your lordship. Lordship, I beg to mention item number 20, lordship. CD not received, lordship. Kindly
20?
fix it.
Yes,
Okay.
what is your prayer?
Kindly fix another short date, lordship. CD not available, lordship.
On the prayer of Miss
S suit.
S.
Suit. S-U-T.
Suit. Council for the petition, the case is passed over for the EP.
May it please your lordship, lordship, I beg to mention.
Here, my lord, item number 20, my lord. Case diary was proper, but it matter has already been, my lord, ended in Sarshet, my lord.
Okay, did you release the case and signs? Since on next date, fixed date.
Your lordship, mentioning for listing your lordship is criminal
August.
petition number 448
Eight,
of
not
25.
not 8 August.
11 August.
Yes.
Yes, this is a criminal petition urgent listing your lordship, 448 of 25. It was last listed on 24/7/20.
Okay, give it to the court master.
Your lordship.
For listing a matter, for criminal revision petition listing.
Daily list for withdrawal, item 1.
Supplementary আছে নেকি আজি? Supplementary আছে নেকি আজি? এইটো নাই দেখোন মোৰ তাত। দি পঠালো নেকি? এখন এক্সট্ৰা থৈ দিব। Yes.
Please to withdraw, lordship.
Mr.
A Dhanuka, lordship.
A. Dhanuka, Land Council appearing for the petitioner, has submitted that the petitioner wants to withdraw the instant criminal petition. You are there?
Yes,
Mr. S. Raj.
Just one.
You're for?
Respondent, man, sole respondent.
Okay. And Land Council for the respondent, who is in attendance, has submitted that the respondent has no objection to the said prayer. So being view of the above submission made by Mr. Dhanuka, Land Council for the petitioner, the criminal petition is dismissed on withdrawal.
Highly obliged.
For motion. Item 2.
Mr. Ahmed,
Hello.
the order dated 19/6/2025
Well,
was passed in favor of
me.
Rustam Ali Sheikh.
Rustam Ali says.
How can you change?
He was the not the
Cannot be.
not the recorded owner.
The person who has approached the court
Court has
of
direct-
stations,
Well,
it is to be him
no, man.
who, no, then I cannot.
Your lordship kindly see.
No, this,
Page 39.
no, A approaches the session court. B approaches the high court
No.
seeking modification. No, that is not permissible.
No, my lord, your lordship, page 39 only for page 39. This is the order. Page 39.
Then you approach press.
Accordingly.
I have seen,
Yeah.
we deliberated, Mr. Ahmed, on that day
Bank
regarding bank guarantee.
Yes.
And I was
Owner of the.
almost convinced.
Yes, my lord.
But question is, allowed to the petitioner.
No,
Hence,
it is mentioned here, owner of the.
I do not
owner.
read, I cannot read what you
Then I will be allowed to, I will,
wants to make me read,
I will.
right?
I-
If A approaches the sessions court,
Man.
then thereafter B approaches the High Court seeking modification. That is not permissible. It is
Right, I
A who has to approach the High Court seeking modification.
will, have-
Otherwise, litigation has no purpose.
I will allow to do and tell.
Mr. J. Ahmed, learned counsel for the petitioner, has submitted that he is withdrawing the instant criminal revision petition in order to file afresh with proper particulars. Yes, Mr. Borua.
Two persons are different.
Mr. R.J. Borua, learned additional public prosecutor for the respondent number 1, State of Assam, who is in attendance, has submitted that the state has no objection to the state prayer. In view of the above submission made by Mr. Ahmed, learned counsel for the petitioner, the instant criminal revision petition is dismissed on withdrawal, with the liberty to file afresh.
Item 3.
May I please, my lord? This is a revision petition. By this revision petition, I am challenging an order dated 4/4/2025 passed by the Honorable Family Court, whereby my lord learned Family Court has increased the maintenance amount from 15,000 to 25,000 while finally disposed of the petition. Now, my lord, before I directly come to the order, I would like to give a brief account. My lord, both the petitioner and the wife, they were studying together at Bangalore, doing their MBA. And thereafter they fall in love and subsequently they got married in 2008. Thereafter, my lord, some dispute has cropped up between the petitioner and the wife. Finally, wife came back from Baroda to Guwahati. And after coming to Guwahati, she has initiated 2 litigation. One is seeking divorce and another is seeking maintenance amount from from her husband. That is the petitioner. Now, my lord, initially I was paying interim maintenance of rupees 10,000. Thereafter, in 2016, that amount has been increased to 15,000, which I am paying. Not exactly 15,000, my lord. It is 14,600 something. Thereafter, my lord, now, my lord, may I kindly come to the order, the operative part of the order, that my lord will find at page 116 of my petition. I'm taking, my lord, to just one paragraph, that is para number 15. My lord, may I kindly have a look at this paragraph? May I allow to read, my lord? Accordingly, the opposite party is directed to pay monthly maintenance of rupees 15,000 to the petitioner and 10,000 to the minor son, thereby totaling up to 25,000. Now, the last line is very significant. From the date of filing of this case, my lord. Firstly, my lord, the wife herself is an educator. She is an MBA. Right now, she is an assistant managerial post, doing her job at the GNRC.
Sir, when this application was filed?
My lord?
When this application
was filed, my lord, in 2013. So, till date, I have paid to my wife around 15,60,000 rupees by way of interim maintenance. Now,
you
if this
continue to
particular
pay,
my lord,
area, so far as area will keep it. Wife's 46,000.
Yes, my lord. She is earning.
You are earning 1,50,000.
My lord, I am not earning 1,50,000.
Oh, you have not denied.
No, my lord.
Have you denied so?
No, I have disclosed.
You have
assets
filed ITR for 18 lakhs.
Yes, my lord.
Right?
My lord.
Paying 3 lakhs of income tax.
Yes, my lord.
Where is the justification? She is earning 46,000. She is also
yes,
living with the son.
No, she is also living.
So far as area is concerned, we can have an order in the form of interim relief. But so far as current is concerned, no.
No, my lord.
If I can take you.
Yes, my lord.
No, you are so ignorant.
No, I am very well aware.
12. You are so ignorant of your child. Come to paragraph 7.
Come to paragraph 7 of
page 112.
Page 112. Yes, my lord. In his cross-examination, he admitted that he is not aware. My lord.
So this you have admitted in your cross-examination. You are so ignorant.
since 2000.
of your children,
Yes, my lord.
that makes it a case for 125.
No,
And plus, it is a fact that you are earning 18 lakhs as per the ITR.
no. As
And
per
plus,
ITR, my lord.
you
it
did
is-
not deny.
My lord,
Have you denied?
My lord, I am
Have
not
you
denying.
denied?
My lord, I am not denying that my salary is 97,000, but my take-home salary is 60,000, my lord.
But why ITR?
Ma-
Why income tax return of 18 lakhs?
My lord, some fixed deposit or some other investment might
Because
have.
they were earning.
My lord, I am not.
Net
denying-
salary is not the only one.
Yes, my lord.
Total income, monthly income from all sources
Yes, my lord.
is material for deciding an issue.
Deeply obliged.
So far as previous area is concerned, we may have an interim order, but not
No, my
25,000.
lord, another aspect I want to bring in. My lord, so far as the divorce case is concerned, her seeking for divorce has been dismissed by the family court. Meaning thereby, my lord, whatever allegation of cruelty and dissertation she brought in, she could not prove, my lord.
But
Now,
125 is a
if
different-
she's staying voluntarily.
125
from me.
proceeding is from a different perspective altogether. Heard Mr. B. Deka.
My
Then
lord,
a counsel for the
I am
petition.
allowed to pay 20,000 rupees per month. my lord.
25,000.
My lord, kindly.
So
my
far
lord,
as area is concerned, that shall remain suspended, but
Deeply obliged, my lord.
because it was increased 14,000 later on from 10,000.
Yes,
Now it is 25.
now it is 25.
Heard Mr. B. Dekal and counsel for the petitioner.
My lord, may kindly make it
So
20,000, my
in
lord.
this,
My lord, may kindly make it 20,000. I will pay monthly.
then you lose the other part also. In this criminal revision petition, the petitioner has laid a challenge to a judgment dated 4/4/2025. Mr. This is under what? Criminal revision petition.
This is a proceeding under section 225, 125, my lord, of CIP.
Family code.
A family court.
You should have made it under Family Courts Act, not CRPC. Because of the non-obstante clause in the Family Courts Act.
But a revision petition.
Okay. But it should be under section 19(4) Family Court Act, not under BNSS. Because there is a non-obstante clause.
Non-obstant.
Piccolo has laid a challenge to a judgment dated 4/4/2025, passed by the Court of Learned Principal Judge, Family Court -1, Kamrup Metro at Guwahati, in FC Criminal 633/2013. Full stop. The proceedings of FC Criminal 633/2013 was registered on an application preferred by the respondent hearing. Respondent number
Respondent number, my lord, only a sole
Respondent
respondent in
hearing.
this case.
under section 125 CRPC, paying for maintenance allowance. Full stop. Tara, initially, the Learned Family Court granted a sum of rupees 10,000 as interim maintenance allowance. Subsequently, the interim maintenance allowance was increased to
14,667.
14,667. 67. Stop. By the impugned judgment dated 4/4/2025, the Learned Family Court, while finally disposing of the application under section 125 CRPC, has directed the petitioner, who was the opposite party therein, to pay monthly maintenance of rupees 15,000 to the petitioner and rupees 10,000 to the minor son. That is, rupees 25,000 in total from the date of filing of the application. First of para. Mr. Dekal and counsel for the petitioner has submitted that the direction to make the enhanced amount of monthly maintenance since the date of the filing of the application is harsh and onerous. First of, the petitioner was diligently paying the interim maintenance allowance to the respondent as per the direction of the learned family court. And till date, he has paid more than
15
yes,
around 15 lakhs, 50,000,
more than 15 lakhs as interim maintenance allowance. Post of the matter required consideration. I have gone through the perused the statements and awareness made in the revision petition. The matter would require consideration. Issue notice returnable in 4 weeks. The petitioner shall take steps for service of notice upon the respondent by registered post with AD as well as by usual process. Post of heard the learned counsel for the petitioner on the interim prayer. Post of it is noticed that the learned trial court, after appreciating the evidence on record, has observed that the petitioner's monthly income is about 1,50,000, whereas the income of the respondent, who is an educated lady, is about 46,000. Post of having considered the factors, this court is of the view that the petitioner shall continue to pay the monthly maintenance amount as directed by the learned family court in its judgment dated 4/4/2025. Post of however, and however, it is ordered, in the interim that that part of the judgment wherein the learned family court has directed to pay the arrear amount at a rate of 25,000 since the date of the application, shall remain suspended till the return.
deeply obliged, man.
Item 4.
May please a loss. My lord, this quashing petition in respect of the Annex 3, my lord, page 47, filed by the daughter-in-law, my lord. Can you see, my lord, page 47,
DV case.
DV case.
Hmm.
Her address, my lord, she has shown, she is claiming many things from the mother-in-law, who is a widow and living with her only daughter, and only son is married to the petitioner, Neha Sharma, and they are living separately since 2007. Kindly see the address of the petitioner, my lord, page 47. It is admitted by herself. And her husband has filed a title suit, my lord, claiming family property from the mother. This is pending in this civil court here in Guwahati. And he is in.
Why the aggrieved person?
Aggrieved person, my lord.
What is her prayer? Only section 18. What is section 18?
Section 18, my lord.
DV.
Admittedly, she is living separately with her husband. Since the year 2000, they got married in the.
The husband lives where?
My lord.
Husband lives where?
Husband with her, my lord. They are living separately. In her petition itself, my lord, your lordship kindly see page 49.
Is page 49? Which
Page
part?
39 in the middle, my lord.
Which part? Paragraph?
Paragraph 4, my lord.
Which line?
My lord, your lordship kindly see. It is in the middle. The father-in-law died. The mother-in-law and the sister-in-law started torturing the petitioner very much. Even the petitioner and her husband.
No, these respondents are, who are the respondents?
Respondent, my lord, mother-in-law, widow, and sister-in-law of the petitioner, that is the sister of the petitioner number 1.
Who is 3 and 4? Ajul, Babul?
3 and 4 is a tenant, my lord, and 4 is a neighboring person, my lord. Because, my lord, the husband and wife, they are quite living separately. They are quarrelsome. They are fighting among themselves.
No, whether husband has any property in his name.
Husband has filed a title suit with against the mother.
So whether
next year.
so husband has any property in his name? No.
He has, because father died, he has the entire property is his, my lord, for which he has filed a petition, suit in the title suit, my lord, page 22.
I can understand so far as petition number 3 and 4 is concerned. Right? They are outsiders.
Outside, absolutely outside.
Right. Now, what is the stage of the proceeding?
Proceeding, my lord, the stage of the proceeding, it is in the initial stage, my lord.
No, there is nothing.
And of course, my lord, we got the orders subsequently, my lord.
You bring it on record, then only by an additional affidavit. You have annexed a copy of the petition.
Yes, ma'am.
Of 2024 without bringing on record the present status of the proceeding.
Present status, my lord, we got the order subsequently, my lord.
Rajbur, you bring an affidavit on record stating the present status of the proceeding. We can understand then only. You have said nothing. 2024 it was instituted. We are in July 2025. What is the stage of the proceeding? Maybe evidence has been recorded, we don't know.
So,
please bring on record, Mr. M. H. Rajbur Bhuiyan, and counsel for the petitioners has submitted that he will bring the present status of the proceedings of DB case number 127/2024 by way of an additional affidavit within a week. The prayer is allowed, place the case after a week in the motion column.
Maybe listed
Motion column.
Maybe listed next week, my lord. I will.
After a week in the motion column.
Item number 5.
What is quashing or what?
But I don't charge it.
Charge 4, section 4.
My lord, while at the time of incident,
Yes.
was evident.
Yes, Mr. Borua, section 4 charge sheet can be.
My lord, I am not questioning for charge sheet, my lord. Then
You want
what happened, at the time of incident, the victim was 17 years, 2 months, my lord. Then now she attained majority. And after attaining majority, they solemnized their marriage. Solemnized their marriage. Is lordship kindly see that
This is not a, my lord, marriage title, my lord. This is simply a, my lord, declaration, my lord.
Declaration, it is affidavit that they also applied for a special marriage act. That
Then the victim can testify before the court.
My lord, yes, that is why I made her party also.
Victim can testify before the court.
Yes.
This is what kind of affidavit, non-judicial. Marriage is done like this way.
The marriage done by the guardian, both the guardians.
Marriage can be done this way.
No, it is just
Before the notary or magistrate.
It is just a notary.
Before notary. Marriage can be solemnized.
It's solemnized socially, my lord. Put the guardians.
Where is that?
I made the statement, and here he lost the signature of the guardian also. He has witness.
Yes, Mr. Bora, section 4 POCSO.
At the time of incident, my lord, she was minor, my lord. At the time of incident, my lord, admittedly she was minor, my lord. Now, my lord, they have said that now they are, my lord, husband and wife, my lord, so they want to, my lord, was the proceeding, my lord. That, my lord, the victim will have to depose before the court below, my lord.
Yes, victim has to depose.
Yes, my lord.
Then, my lord,
Cognizance taken, my
It
lord.
is not that section 8 or section 10. It is section 4.
but
Cognizance taken section 4.
case was registered as section
Cognizance
8.
taken under section 4.
TVR of all.
My lord, 17 years.
8 or 10 I can understand. But is aggravated.
My lord, however, the Honorable Supreme Court
In-
also held in similar cases.
Where is? Let us see. If it is so.
In our
Don't show 325 or 327.
and how
307.
High Court also,
Not so matrimonial offense.
High Court also granted quashing similar.
Yes, I have also done 100.
This way cannot be done, my lord.
Marriage certificate will come, my lord. 1 month not.
There was a marriage certificate.
Yes.
Supreme Court got it verified.
Yes.
Right?
Yes.
It was a Register of Hindu Marriage Act. And the couple had 2 child. Right? As against it, you have a notary agreement.
I'll publish the. We also applied for the special marriage act. That certificate
if
not
you-
come.
That notary agreement.
No, I'll bring that certificate, my lord. 1 month not completed. I already applied for the special marriage act.
Everything can be done in notary agreement, but that is
No,
the
I'll publish that certificate.
better to
just
have
it will be
better
come.
to have date certificate so that we can get it verified, because Supreme Court got it verified. Because many a times
And another case also.
to escape from the clutches of law,
Yes.
people may resort to anything.
And my next case also, my lord, similar.
So here it is. Okay, we can go by Supreme Court judgment. We cannot have this. Other High Court, Supreme Court, yes. Yes, sir. But at this stage,
So and notice go, my lord, let there come fathers, I made party, and informal also made, CS also made party. I will allow to take justice service also. And in the meantime, I will publish that certificate also.
But we will not stop the proceedings of Sessions case. Don't expect us. If your wife can go there and justify, it is well and good.
Yes. In the meantime,
He can go and testify. Heard Mr. J. Ahmed, learned counsel for the petition, and Mr. R. J. Borua, learned additional public prosecutor for the respondent number 1, State of Assam. Post of the petitioner is seeking setting aside and quashing of the proceedings of any POXO case number?
Yes, POXO case number, page 1, my lord. POXO case number 64 of
64 stroke
pending in the Court of
2025
Special-
pending presently pending before the Court of Learned Special Judge POXO Morigaon. Post of on submission of the search sheet, the Learned Special Court has by order dated 3/4/2025, taken cognizance of the offenses under section 366 IPC and read with section 4 POXO Act, and for the purpose of initiating the trial, issued summons to the petitioner, who has been shown as an absconder in the charge sheet.
Because name was Amrul Hussain.
Post of.
My actual name is Kamrul Hussain.
Sarsit dated 28/2/2025. Post of para, Mr. Ahmed, learning counsel for the petitioner, has submitted that during the interregnum, the petitioner has entered into marriage with a victim of Lahori Ghat police station, case number 79/2024 under the Special Marriage Act.
Now, it is, but they also applied, they also applied.
Applied, not solemnized.
Now, marriage socially solemnized, thereafter they applied.
Socially.
Socially solemnized.
And
Both the guardians.
then why we should keep it pending? We are not going by the notary.
This is not notary, my lord. Whether this power is, well, it is executed by one chief administrative officer, district and session judge. Whether they can execute this type of agreement or not, that I do not know, my lord.
We have not. All this is then fraud. And see the language. See the language of these agreements. Very tactfully drafted. Read yourself and get satisfied.
I have seen. I seen.
Get satisfied. Then you make me
Husband shall
satisfied.
never marry other persons.
Is it talking of any marriage? Page 33.
Yes. Page 6, Mohana was fixed, they have stated.
Cleverly drafted. Clever drafting. Piece of clever drafting.
Let after some this I will.
No, you cannot keep on pending like equated monthly installment. On the next day, you will submit another document. You are yet to enter into special marriage. This is a document which does not indicate marriage. You said socially. Where have you said? Sometime 18th. 18th, after receipt of summons, after Sarsit.
After Sarsit.
After Sarsit.
Because he was attend majority on my lord. March 2025.
Well, simply issue notice, returnable in 6 weeks. The petitioner has Mr. Borwa, additional public prosecutor for the respondent number 1 from the state of Assam, has appeared and accepted notice on behalf of the The petitioner shall take steps for service of notice upon the respondent number 2 by registered post which AD as well as by usual process
2 and 3 miles
within 2 and 3 by within 3 working days from today. We'll see. Let them appear. Let them appear.
I'll make a justice service also permitted.
Let them appear, but this affidavit is of no purpose.
I'll do in the meantime, certificate will come, my lord. My lord, I may take justice service also, my lord.
Okay, 10 লিখে দিব 10 দিন by usual process.
As well as register post.
As well as এখানে Mr. Borwa, you take note of these judgments.
No, my lord.
Take note of the judgment. Many times this kind of matter comes. Then hand it over to Mr.
I'll give the photocopy.
Possible for the day, Lordship, I should is the some medical issue, Lordship, so he going to medical. Tomorrow may be fixed.
Oh, motion states if you go on taking adjournment, it will pile up.
Lordship,
See tomorrow's situation.
Tomorrow may be fixed, Lordship.
Are you aware of the case?
Not able.
Huh?
Not
You are
able.
taking adjournment for 2 days on 2 occasions.
Lordship,
Huh? You have not read it. You have not read it. Good. Your name is there in the call list.
yeah,
Is there.
yes, Lordship.
Still you have not read it. So you have come to the court for making a prayer for adjournment.
No, Lordship, but today, suddenly medical issue. Tomorrow may be fixed, Lordship.
The instant criminal petition under section 528 Bharatiya Nagarik Surakha Honita is preferred to assail is preferred for setting aside and quashing of the proceedings initiated proceedings of NI case number 57/2021 presently pending before the Court of Learned Chief Judicial Magistrate, Dibrugarh. Oh no, huh? So, para. The respondent hearing as the complainant instituted a complaint before the learned trial court. Under section 138 of the Negotiable Instrument Act, alleging dishonor of a check issued in her favor by the petition for an amount of rupees 5,38,000 on an account maintained at Vijaya Bank, Hilpukhuri, Guwahati branch. Post issue notice returnable on 4 service. The petitioner has contended that the check dishonored check was issued by the petitioner as an authorized signatory of Messrs. Kamaiya Engineering Services Private Limited and not in his individual capacity. Full stop. It is the further contention of the petitioner that in the proceedings of NI case number 57/2021, comma, the petitioner has been arraigned as an accused in his individual capacity, not as an authorized signatory of Messrs. Kamaiya Engineering Services Private Limited. Full stop. Furthermore, comma, the complainant has not implemented Messrs. Kamaiya Engineering Services Private Limited, for which the petitioner as an authorized signatory had issued the check in question. Full stop. But in view of such projections, comma, this court is of the considered view that petitioner has made a prima facie case. And accordingly, it is ordered, comma, in the interim that further proceedings of NI case number so and so, presently pending before the court of so and so, shall remain suspended till the returnable date. Issue notice returnable in 6 weeks. A petitioner shall take steps for service of returnable question. Petitioner shall take steps for service of notice.
1st September. Item 7.
Well, that 7 and 8 may be taken up together, man. On the last occasion, my lord, Lordship has heard the matter, my lord, and has asked.
What question I asked?
My lord, the trial court has given, my lord, maintenance of, my lord, 2,000 to the wife, 2,000 to the daughter, and 2,000 to the son, totaling 6,000. Then, my lord,
Enhanced.
yes, she preferred an application before the, my lord, session judge. Then it was, my lord, enhanced to 24,800. That, my lord, we had.
Okay, all EMI, etc. included. Yes.
As your lordship remember it, my lord.
No.
Yes,
what question I asked, I forgot.
Yes, my lord. Lordship has, my lord, that originally, my lord, that 6,000. Then it was enhanced to, my lord, 24,800, my lord.
2 sons.
One
You had-
son, one daughter.
Okay.
24,800.
Dibrugarh. And the other place?
Titabar, my lord.
Okay.
For that reason, my lord, it has been, my lord, that revisional court has enhanced to, my lord, 24,850. That, my lord, we have challenged. Then, my lord, lordship has, my lord, stated that, my lord, if we can pay the, my lord, the earlier, my lord, maintenance, that is 6,000 with arrear, my lord.
You are following in a year also?
Yes. That how much we can pay, my lord.
And about your status, you are saying retailer.
Yes, my lord.
I know ITR.
I have got a, my lord, grocery shop, my lord. But wife has stated that, my lord, I have got wholesaler.
Yes.
So
And your ITR.
ITR also, ITR not, my lord, one certificate has been given.
Who?
That, my lord, district authority.
Oh, no.
That cannot be relied on.
Cannot be.
Yes.
Absolutely not.
But I am a, my lord, I have got a shop, my lord. And, my lord, till 23,000, my lord, she was, my lord, on and off with me, my lord. Though this petition was filed in the year 2019. Even, my lord, I have asked my client, my lord, whether, my lord, some negotiation could be made and she could come to me, my lord.
Okay. If you can serve her a dusted and mediation as a mission is going on.
Yes, ma'am.
So we can put both of you there.
Yes, but that
Process of mediation is going on.
Could also be tried, my lord.
But what about?
Only thing is, well, there is a non-bailable warrant, second petition, my lord. Item number 8. Here is a non-bailable warrant of arrest against me, my lord.
Where is the judgment?
My lord, in the second, my lord, item number 8, my lord.
1 minute. Where is the observation that you did not pay the arrear?
Yes, my lord. Lordship will.
Because you did not appear in the proceedings, original
Yes,
proceedings,
yes.
in spite of opportunity.
Advocate, my lord, appeared. And my lord, my instruction is that, my lord, at the instance of my wife, my lord, this advocate was engaged. Because, my lord, they have got visiting terms, my lord, till 23. Now she is settled at, my lord, Dibrugarh. I am in Titabar. My shop is at Titabar. I will pay some amount, my lord, and
Would pay some amount will not do.
my lord, I will pay, my lord,
All
because
are eligible
if we
to
go by the, my lord,
monthly
trial judgment.
To pay.
Trial court has come to a finding, my lord, that my income could not be proved.
A majority. Standing total. Earlier you paid how much?
About, my lord, 34,000.
Earlier you paid monthly how much total?
I have not paid anything, my lord. Sometime, my lord, I have paid, my lord, like
Oh,
that.
then you are defaulter.
I am a defaulter, my lord. That is why, my lord, I am, my lord.
What was the earlier order? How much? 6,000.
6,000, my lord.
2,000 to each other. 2. Earlier 2 plus 2 plus 2, 6.
Yes, 6.
Now?
Now it is, my lord, total, my lord, 24,850, my lord. Worship will find Sessions Court, my lord, at page, my lord, para 15. At page 41, my lord, in my
Pay
revision.
10,000. EMI. You pay the area 6,000 at least
I will pay that, my lord. I am ready to pay that, my lord.
from the date of the maintenance petition.
Yes, that I have calculated, my lord.
How much?
That comes, my lord, 4,32,000. Plus, my lord, another 6,000 has been given, my lord, totaling to 4,38,000. So, my lord, immediately, my lord, in the next date fixed on, my lord, in the 21st of August, my lord, I will pay, my lord, rupees 1 lakh, my lord.
Oh, that will not do.
My lord, he is a petty shop owner, my
Oh,
lord.
petty shop owner.
Hereafter,
Cannot be.
some installment, my lord, I will make the payment, my lord.
Deposit 1 lakh and you continue to pay this one.
6,000, my lord.
You cannot be.
Yes, sir. I am ready to pay that, my lord.
Oh, you're not showing inclination.
My lord,
When was the original order?
original order, lordship will find a page, my lord.
Six 7 2023. And the petition was filed in 2019.
19.
Nothing we have paid.
34,000 I have paid only.
Oh, this
Only
must.
34. Only 34.
You have one son, one daughter,
Yes.
and one wife. You are paying 34,000 since 2019.
But my lord,
Poor so, Mr. Chaudhary.
yes, but
Poor so.
only thing is, my lord, up to 23,
Poor so.
my lord, she was with me, my lord, with my son and daughter.
Why then the lady will file the maintenance application in 2019
Yes.
and will not withdraw if she was really with you?
My lord, she sometimes comes to me, sometimes, my lord, she stays in Dibrugarh, my lord.
You are not paying anything. When was the order, interim order? When was the interim maintenance
Interim
order?
was not there, my lord. Finally, it was on, my lord, 6/7/2023, right? 6/7/2023, my lord. Hereafter, my lord, she filed this, my lord, enhancement petition.
Okay, subject to deposit within 1 month. All the area at the earlier rate.
All the area will be, my lord, difficult, my lord. Other, my lord, he has to be behind the bar, my lord, and nothing could be paid, my lord.
But you are showing nothing bona fide. You are showing no bona fide actually.
That is
Since 1997.
only problem, my lord. Because
You were aware of 125 proceeding?
Yes,
Despite opportunities, you did not appear and contest. You make it ex parte.
it was ex parte.
Ex parte.
My lawyer was there, my lord.
Then thereafter also you did not prefer appeal. You agreed to it.
Yes, 6
Meaning that since you did not prefer any revision
my lord.
of that order,
Yes.
so you agreed to it.
Yes.
You agreed to it, but you did not pay.
That is, my lord, that area was too much, my lord. From the day
How
of
can
my
it
lord,
be?
from the day of my lord filing.
Not
the-
showing bona fide, that is a problem.
My lord, now I will show bona fide, my lord.
Show bona fide by area, then we'll observe this.
My lord,
We can reduce it.
within 1 month, my lord, I am paying 1 lakh, my lord. Yes, my lord, with installment, my lord, I am paying it as per your.
And this modification will be subject to the outcome. We will not touch this. 1 lakh you pay?
Yes, my lord.
1 lakh you pay within 1 month.
Yes.
And you continue to pay as per the direction of the revision code.
24,500 per year.
Still you are saving 3 lakhs.
Yes, my lord. I will agree that. Above?
Otherwise, son and daughter,
Yes, I agree.
they
my lord.
are school-going children.
Even my lord,
You paid 34,000 for last 6 years. Heard? Or so, Mr. Chaudhary.
yes, my lord, I agree, my lord.
B.M. Chaudhary, Learned Counsel for the petitioner. First of the petitioner has laid a challenge through this criminal revision petition to a judgment, an order dated 14/11/2024 passed by the Learned Additional Session Judge, passed by the Court of Learned Additional Session Judge Dibrugarh in criminal revision number 18 within bracket 3/2023. First of where it is pertinent to state that at an earlier point of time, the respondent, wife of the petitioner, instituted a proceeding under section 125 CRPC seeking monthly maintenance for herself and her 2 minor children from the petitioner, and the said proceeding was registered as case number 45 within bracket Uparat capital M of 2019 before the Court of Learned Judicial Magistrate First Class Dibrugarh. Full stop. Despite grant of opportunities, the petitioner allowed the proceedings of case number 45 M 2019 to proceed ex parte, and a judgment was delivered therein on 6/7/2023 by directing a maintenance amount of rupees 6,000 in total to the respondent wife and the 2 minor children of the petitioner, full stop, seeking enhancement of the said maintenance amount, the criminal revision number 18/2003/2023 was initiated. Full stop. The petitioner contests the proceedings of criminal revision number so and so. Post of the Learned Revisional Court, after appreciation of after considering the claim for enhancement of the respondent wife, enhance the amount of maintenance to rupees 24,850 in total, with breakups shown under different heads. Full stop. The 2 children of the petitioner has been directed to pay an amount of rupees 6,000 each till they are attaining the age of majority. Full stop. Para. দুইটাতে লিখি দিব, হ্যাঁ, দুইটাতে লিখি দিব এইখিনি কথা। তাহলে প্ৰথম পেৰাটোত ইটোৰ প্ৰথম পেৰাটো লিখিব which is the impugn order here
My lord, in the. item
24
number
5
8, my lord.
24 5 2000 second truth 24 5 2025
25.
whereby which court
My lord, Court of.
Court of Learned
Judicial.
Judicial Magistrate First Class Dibrugarh has issued non-bailable warrant of arrest against the petitioner due to defaults
My lord.
made by the petitioner in depositing the maintenance amounts.
Movable articles, my lord, there was no movable article.
No, for what it was initiated.
First, there was a distress warrant, my lord. Then there a report came, my lord, that there is no movable properties, my lord. And straight away, my lord, NBW was given. Here, my lord, the magistrate ought to have done, my lord, gone for, my lord, the bank and, my lord, immovable property.
Gone for?
Or, my lord, my bank account, etc. Or, my lord, any immovable properties, my lord. But here, my lord,
But
non-bailable warrant.
he is trying to secure your appearance.
My lord.
Distress warrant is for what?
Distress warrant for realization of the, my lord, all this area of money, my lord.
Did you appear there?
I appeared once, my lord, and on that day I paid 7,000 rupees, my lord.
লিখিব second লিখিব whereby non-bailable warrant of arrest has been issued against the petitioner due to default made by the petitioner in depositing the maintenance amounts to his wife and two minor children in terms of the judgment and order dated 14/11/2024 passed by the Court of Learned Additional District and Session Judge Dibrugarh. First of, What second truth? From the materials on record, it has emerged that despite the direction to pay an amount of rupees 6,000 from the date of filing of the application in case number 45M/2019, the petitioner has failed to pay the same regularly. As a result, a large amount of about 4,000 has fallen in arrears.
4,32,000.
I have said about
4 lakhs, yes.
about 4 lakhs has fallen in arrears. Full stop. Incidentally, the petitioner did not make any challenge to the judgment dated 6/7/2023. Full stop. It is the respondent wife who has sought enhancement of the maintenance amount from rupees 6,000 to rupees 75,000 per month in criminal revision number 18 within brackets 3/2023. Full stop. Para. Mr. Choril and counsel for the petitioner has submitted that the learned court has determined, learned courts have determined the maintenance amount on the basis that the petitioner is running a business as a wholesaler whereas the petitioner is only a retailer. Full stop. The trial courts have had to accept the I have taken irrelevant factors into consideration to determine the enhanced amount of rupees 24,850. Full stop. Be that as it may, full stop. Issue notice returnable on so and so date. Have প্রথমটো লিখিব, having regard to the projection made on behalf of the petitioner and the reasoning assigned by the courts in the respective judgments, I would consider view that the petitioner shall have to deposit the arrear amounts at least in terms of the judgment dated 6/7/2023. Apart from the direction to give direction as regards enhanced maintenance amount, full stop. It is therefore ordered in an interim that the petitioner shall deposit shall pay an amount of rupees 1 lakh to the respondent wife on or before the returnable date.
On the next day, my lord, on 21st, case is fixed, my lord. 21st of August.
1 minute. On the on
21/8/2025.
21/8/2025. That is the date
Before the my lord,
fixed before the court of learned CGM.
CGM for making the payment.
And full stop. In addition, till the return, on month. In addition, the petitioner shall continue to pay the enhanced amount of rupees 24 so and so since the date of the judgment. What is the appellate court judgment?
Page 29, my lord.
14/11/2020.
14.
You paid that amount. You have come late or what?
My lord.
You have come late. Okay.
14.
You waited also. Thereafter also you waited.
No, my lord, because
When distress warrant non-available, then you arose from deep slumber. Okay. In addition, shall continue to pay the sum of rupees so and so as maintenance allowance since the date of the judgment by the revisional court on 14/11/2024. The other parts of the total going to pay second to লিখিব same লিখি পেলাই লিখিব subject to compliance of the above direction from the non-available warrant of arrest issued against the petitioner shall be kept in abeyance till the returnable date. Second, I think
second that my lord,
kept in abeyance.
my lord.
You pay, condition is same in both.
I will make the payment.
Same, 1 lakh
1 lakh, my
on
lord.
21st.
That, my lord, I can.
And you pay the enhanced amount since the date of the revisional court.
Lordship will kindly record, my lord, on or before, my lord. If it is possible, my lord, I will make the payment immediately.
On or before.
On or before, my lord.
No, then will not make it complicated. On or before the returnable date. We are making a returnable
My lord.
here,
Obliged worship.
subject to compliance of this. That's right. NBWA is kept in abeyance.
আমি obliged.
Item number 9.
Steps can লিখি দিব, steps. Register post and as well as by usual process.
Wait, please, Your Lordship. This is the quashing petition.
Yes.
The allegation is of 498A. Now, the mother-in-law is before Your Lordship.
Yes, Mr. Borua. How old is he? Yes.
The allegation against her, my lord, in the FIR, Lordship, may kindly peruse the FIR, my lord.
We don't know which one is correct, which one is wrong. 498A.
She instigated her son, my lord.
Huh?
It is the allegation in the FIR.
Now I have been told it is the survey, result of a survey. Shocking things have emerged that POCSO cases are also filed. The aim is to section 357 CRPC, irrespective of the outcome. CRPC 357. That things have emerged in a survey. Yes. Mother-in-law.
Page number 25, my lord.
Page number 25.
25 middle portion, my lord. This is not very legible, my lord, my copy.
My copy also.
Do you know Podoke Murhahu?
Let us hope that English translation is correct.
To the best of my ability, I have translated. In middle, however, about 2 years ago, the accused number 1, my husband, on being instigated by accused number 2, Srimati so-and-so, had tortured me mentally and physically by demanding dowry. First of all, this FIR has been lodged
Yes,
after 2
this
years.
is the allegation only.
This is the allegation, my lord. Now, my lord, this, someone has been issued, my lord, case has already been charged, my lord. So let them appear, my lord, let them file application.
My lord,
Mother-in-law, you know,
may I also?
everybody saw that hard, Mr. J. Bora.
J. Bora.
Land Council for a petition. And Mr. R.J. Borua, Land Traditional Public Prosecutor for the respondent. Number 1, State of Assam. Full stop. The petition in this criminal petition under section 528B and SS has challenged the proceedings, criminal proceedings of PRC case number. PRC case number?
My lord, PRC.
2005.
2005/22.
Why is after so much delay?
My lord.
Why after so much delay, case is of 2022?
My lord, if your lordship comes to page 32, the order sheet, it will transpire. My lord, sometimes the magistrate was not there and the summons were not received. Only after
2022 presently pending before the Court of Landed Chief Judicial Magistrate, Kamrup Metro at Guwahati. Full stop. The case, PRC case number was registered on the basis of a first information report lodged by the respondent number 2 as the informant before the officer in charge, Hajo Police Station, on 6/2022. Post of in the FIR, the petitioner, sorry, the respondent number 2 as informant had arraigned the petitioner and her son, who is the husband of the respondent number 2 informant, as the accused persons. First of an allegation was made in the FIR against the petitioner to the effect that it was at the instigation of the petitioner, the husband of the respondent number 2 informant they used to torture her mentally and physically by demanding dowry. Full stop. The upon investigation, a charge sheet was filed wherein the petitioner has been charge sheeted. Full stop. Finding a privacy case against petitioner and her husband, her son, have been charged sheeted. Finding a privacy case for the offense under section 498A IPC read with section 34 IPC. Full stop. Para. Issue notice return bill in progress as Mr. Borua, respond number 1. The petitioner shall take steps for service of notice. I will respond number 2 that's informant by registered post AD as well as by usual process. Full stop. Having regard to the allegation made in the FIR against the petitioner, it is ordered in the interim that the further proceedings of PRC case number so-and-so presently pending before the so-and-so shall remain suspended till the returnable date insofar as the petitioner is concerned. But your husband should appear, your son.
My son is. And moreover, my lord, just for my own satisfaction, my lord, page 17, it was only an agreement for marriage. Marriage never took place.
We don't know.
Yes. Okay.
Item number 10.
Yeah, please, your lordship.
You said something in the morning?
Yes, your lordship, but I'm fortunate that I've been able to manage the time.
Yes.
Your lordship, my complaint case, I have come here for quashing and setting aside of a complaint case. Lord. Operative
What is
portion-
your legal ground? After withdrawal of the case by the prosecution?
Yes, your lordship.
Second complaint.
Moreover,
We don't think so.
moreover, your lordship, may I please? My matter is absolutely of civil nature, but a criminal color has been given to it. Moreover, it is.
Where is your complaint? Where is the complaint?
Operative
Where is the
portion,
complaint?
page number 23, your lordship. My complaint is absolutely baseless. Why? At night, 2 a.m.
Baseless is different thing, Mr. Counsel. We have to see whether in the complaint or FIR, the ingredients of any cognizable offense are made out or not.
Indeed.
Baseless, true, false, we are not into that for the purpose of quashing. So baseless, all these things, you concentrate on the contents of the complaint. That's all. This is an extraordinary power, inherent power, and law has been long settled from R.P. Kapoor through Vajanlal.
Indeed.
So baseless, false, all these things has no value. Right?
Yes.
Whether ingredients of the offense are made out or not, thereafter we'll examine if in the background this is a mala fide action or not. First, we have to see whether these ingredients of the offense are made out or not. Right? Civil can coexist with criminal. Right? It can be separated sometime. It cannot be separated sometime. Right? Let us see.
So, your lordship, at night 2 a.m., 25 numbers of people have come to my land, have trawled fishes from my land.
Who is the complainant?
Complainant, there are 20.
Rafiqul.
Yes, your lordship. Rafiqul Islam.
Okay, and these petitioners are made respondents.
Respondent.
Okay, let us see now.
In the CR.
Contents of the complaint.
Operative portion, page 23.
Because there was a police case.
No, your lordship. At first, in the year 2017, case and FIR was lodged before the police. It was subsequently sent before the court. Cognizance was taken, charge sheet was filed, and then this withdrawal was done.
In the charge sheet, these petitioners were charge sheeted or not?
Only four of them were charge sheeted, Your Lordship. Others
Only?
were not, because material evidence was not found against them.
Who is that?
Your Lordship, due to paucity, my my petitioners could not be able to manage it on time, so I have not been able to annex it. But if allowed, additional
No,
affidavit can be.
You file additional because if really in
Yes, Your
the
Lordship.
earlier police case, on the same set of allegations, after investigation, 4 persons have been charge sheeted out of these petitioners. Right? And thereafter, the instance of the PP, the case is withdrawn. Thereafter, this complainant has submitted the second complaint. Right? In that case, including more persons, other than the 4 charge-sheeted person, right? The other persons may have a case. And on the issue of second complaint, if he has no role in the withdrawal, it is the state.
It is the state.
State doesn't want to prosecute as part of the policy. But why a victim should be rendered remediless? He can file. I don't think there is a legal bar.
Obliged. Yes, Your Lordship.
But if you say that in his complaint, now he has roped in more persons as an accused after the police investigation, right? Then you may have a case, but you have to show me the material. Otherwise, he has made out a case. But previous things are not brought on record.
Your Honor, due
That
to
is-
the like plausible
that is the
file
problem.
and things from
That is the problem.
Learned Court in the Morrigaon, because it's a long pending case, 2017.
You bring out on record then that if it is really true that only how many petitioners had? 23.
23. Two of them have died, Your Honor.
Out of them, only 4 were charge sheeted.
Yes.
And he was happy with that.
Yes, sir.
Now he cannot become unhappy. Have you got the point?
Yes, Your Lordship.
Give it transcript copy. Bring it on record.
Your Lordship, my humble prayer, at least LCR may be called. I'll submit this.
I'll not call LCR first.
Returnable date.
First is the satisfaction of the court. This court does not call for LCR just at the instance of the council.
No, not at my instance, at your own convenience.
So it is up to you. As on that, I am not deriving satisfaction. You get it on record as an additional affidavit with a correctly and properly translated copy, then we'll decide. If your submission is true, then yes. So far as other than the 4, they have a case.
They have a
and
case.
For the 4, we'll examine.
Obliged, Your Lordship.
I'm making it clear.
I get your point, Your Lordship. Much obliged.
On Mr. Surlani, constable of petition, has submitted that he will bring the copy of the charge sheet
Of the GR case, Your Lordship.
of GR case number
111.
111 of
2017.
On record by way of an additional affidavit within a week. First establish the case on so and so. As
GR
prayed for.
111.
I am giving a fixed.
Your Lordship, 7 days time. I shall-
7 days time I am giving a fixed date also.
11 August. 11.
Much obliged.
Item 11.
Yes.
Made to Your Lordship.
What is this bulky petition?
Your Lordship, it's a bulky petition, I admit, Your Lordship, but at the same time, very small question.
Or criminal petition?
Your Lordship, it's a very small question of law is involved here. Because the only question that is involved here, what would constitute the 68th day of filing a charge sheet if the 68th day is a holiday? Now, the only point of interpretation that was actually left for the.
What has been interpreted? Which is the order?
Yes, the order is an annexure 1, page 85, and the findings start at page number 90.
90.
90.
What is it about? What is it about?
Basically, the respondents, they were arrested for smuggling gold. And in fact, they had
Customs Act. Customs Act.
Customs Act. And then they were actually enlarged on bail by the learned trial court by the learned CJM on the ground that the charge sheet was filed on the 61st day, Monday. But that 60th day actually fell on Sunday. So as per the law, in effect, section 470 of the CRPC, because at that point of time CRPC was followed in this particular case.
470.
470.
CRPC.
Yes, Your Lordship.
No, maybe.
471. I'm sorry. 471.
471.
As well as read in terms of clause, section 10 of the General Clauses Act.
471.
1. Exclusion of date on which court is closed.
Yes.
If I may just read out, Your Lordship.
What is the fixed date? Let us see the date.
Dates.
Relevant date, page
Yes.
86.
Relevant dates, Your Lordship.
What is the date of?
Date of arrest is on 13/3/2024.
13/3.
3/2024. They were remanded to judicial custody on 14/3/2024.
So what is the date for counting?
The date of counting starts from the day of remand, as per the law laid by the Supreme Court. I'll produce that judgment also.
Okay.
The date of remand is 14/3/2024. So the 60th day, it was supposed
Charge sheet was submitted when?
on 13/5 at
13/5.
4:45.
60-day period.
60-day period ends on 13/5.
Okay. March is what?
March is 31st, 31 days. 17
April
days.
is 30.
April is 30 days and
1
May
minute.
is 30.
47.
So the 60th day
Huh.
falls on 13th May 2024.
13 May. Yes.
We filed it on 13th May 2024.
Huh.
But the impugn order, which is at Your Lordship will find at page number 96. Annexure 2. 13/5/2024. If I may just read out, Your Lordship.
The order is also 13/5.
13/5. Case record is put up today in view of the petition number so and so, dated so and so, 13/5, filed on behalf of the accused persons, namely so and so, praying for enlarging them on bail. It is stated that the said accused persons are in judicial custody since 14/3/2024 and they have completed 61 days as on date. I have heard both the sides and peruse the case record. Perusal of the record shows that the IO has not yet filed charge sheet in the instant case till 4 p.m. today. We filed it at 4:45 p.m. The record also shows.
So what is the court hour?
Your Lordship, it was accepted.
No, court hour.
Court hours, Lordship.
Official court hour.
Official court hours. I am not aware of it, Your Lordship. The official court hours.
Oh, it is official court hour. Let us see once again. 471.
471, Your Lordship.
Explanation.
A court shall be deemed to be closed on any day within the meaning of the section if during its normal working hours it remains closed on that day.
So there is a mention about normal working hours.
Normal working hours.
What is the normal working hour of the court?
Lordship,
Acceptance is different thing.
But in fact, we had stated, we had actually said before the learned trial court.
Now, what is the reasoning
today?
What about this 440? It has said that up to 4 p.m. today.
Up to 4 p.m. today.
Also, the accused person is.
The record also shows that said accused persons.
So far as custody. 61 days is concerned, it appears to be 60 days.
60 days.
Right. But there is another question. Charge sheet was not submitted within court working hours.
Yeah, Lordship, even then also.
Because once a court sits during normal court working hours,
Lordship,
I've been told, suppose the court rises.
Yeah, Lordship, I would say it is actually 59 days because 11th of April was 11th of May was the second Saturday.
No, that cannot be.
Your Lordship.
That logic is not there.
Your Lordship,
11th of May is Sunday.
Sunday was 12th and 13th of May is a Monday.
When 13th May is what?
Monday.
Monday. Then you do not get the benefit of Sunday. You do not get the benefit of Sunday.
Your Lordship,
If 13th was Sunday, then you would have got the benefit of 14th. 12th is Sunday.
Your Lordship, we fight.
That would not inure any benefit to you.
Your Lordship, even
Now, question is now limited to it appears in my estimation, it is 60 days
60 days.
on 13/5/2024. Now, next question is, what is the court working hours?
Court working hours, Your Lordship.
Because
it is-
there is another view that suppose my time is 4:45. I rise. Then without any official notice, if I pass an order, then that can be challenged as an illegal order. If I again sit at 5:30 without any notice, without public notice, right, and pass an order,
Agree.
that can also be challenged as an illegal
Your
order.
Lordship, let me then find out the
So,
working hours of.
that is the only thing, 4:40. You said, where is the statement that received acknowledged at 4:45?
Yes, Your Lordship, the acknowledgement is at Annexure 3, page 97. At the top left-hand corner, there's a stamp. Received on 13/5 at 4:45 p.m.
Okay. This is by the court of CGM court.
CGM court.
Official. Okay. Then you
I have only actually annexed the first.
find out 4:45. High court time is 4:45, but find out. Do you have a criminal manual practice? Find out. You can take it up day after tomorrow.
Yes.
Find out 4:45 is the time or. But so far as 13 is concerned, 13/5/2024,
Yes.
I think perhaps the learned court has gone wrong. It would be 68th day,
68.
right? But on the 68th day,
The court working hours.
whether it would be up to midnight or it would be up to court working hours. That's all.
That's all.
Okay. On the request of Mr. D. Bora, Learned Senior Standing Counsel, DRI, for the petitioner, lays the case on. Yes, Mr. Bora, can you highlight? Can you highlight as an officer of the court any assistance?
My little knowledge goes, my lord, charge sheet has to receive, my lord, in the office, my lord. And the endorsement has to be there, my lord, on the 68 or 98 days, my lord.
Huh?
On the 68 or 98 days. Now, my lord, as per my lord, the provision of 471 CRPC, my lord. Now, what he has submitted, my lord, since it was a Sunday, my lord.
No, not Sunday. Monday.
No, my lord, 68 days was Sunday.
No, Monday.
Then, my lord, there is no. If the 68 days is Monday.
No, what is the court working hour?
Court working hour, my lord, normally in my lord, in our judiciary.
Normally will not do.
No, in our judiciary, about 10:30 to my lord, 4:30, my lord.
And whether there is anything, because the accused making a prayer for bail,
my lord,
or it is his remand, maybe,
my lord,
whether he can be kept in the court.
my lord, in this respect, my lord, I beg to submit one thing, my lord. Normally, my lord, when the charge sheet, my lord.
No, here normally, usually, ordinarily will not do.
I have not seen, my lord, during my practice period, my lord, the charge sheet is placed before a judge, my lord, while he was sitting in the court, my lord. Because it is always, my lord, after the rising of the court, my lord, the charge sheet and all the materials are placed before the court.
We are aware of it.
My lord.
I am asking you, what is the court hours?
My lord, 10:30 to 4:30, my lord.
Then it is beyond court hours. Court working hours, office working or court working.
My lord.
Sometimes you made the say official or staff
My lord.
to work beyond court hours
My lord.
and made to accept the document,
My lord.
trust it. Whether that will be proper or not, that is a different thing. What is the court working hours and office working hours? Tell me, that's all.
My lord, court working hours is, my lord, 10:30 to 4:30. My lord. Office working hours, maybe, my lord, 10 from start
Kind
from
of
10 o'clock, my lord. That I'll find out, my lord. I'll find out from the judiciary, my lord.
Otherwise, accused has a right. As soon as the court or office working hour
my lord.
for submission of charge sheet is over, whether that indefeasible right under section 167
My lord.
gets activated or not activated. That's all.
Lordship, the law as such, I'd like to differ on this particular issue. The law which has been laid on the Supreme Court says that indefeasible right would actually arise when the bail bonds are filed. The bail bonds are filed
Show
sometime
me.
later. Yes, sir.
No,
Show me.
that I'll
Bail
not
bond,
agree,
I
my lord.
don't
That
think.
I'll not agree, my lord.
I'll
not agree, my lord,
but I am not privy to such decision. Maybe there are decisions, but I am not privy to that decision. We'll give it on next day.
Next day. Day after tomorrow, Your Lordship.
Item number 12.
Next, Your Lordship, Lordship, it is a quashing petition. Lordship, as I had at page 11. Allegation of gang rape is there, Lordship.
Yes.
Lordship, as I had at page 11.
Read.
Lordship, with due respect, beg to state that.
I have read. Then charge sheet.
Lordship, the case is charge sheeted, Lordship. Already charge sheeted. And Lordship, I take your Lordship to medical report that I have annexed. Lordship, kindly have a look at page 28 is the type copy, and the Lordship photocopy of the original page 29 in 30. Allegation of gang rape, Lordship, and Lordship kindly have a look at the medical report.
So, on this basis, quashing.
Lordship, and also Lordship, I am relying on the 161 statement. Lordship may call for medical report.
Medical report is not the Bible.
That is true, Lordship, but
in a case of
if no case at all, Lordship.
no case, it cannot be said.
But Azahar, there is a case.
Law is not that.
Azahar, there is a case.
Medical, which one is to be prevailed, oral or medical?
Lordship, Lordship.
Only inconsistent is a different thing. But on the basis of medical evidence, what is this notarial certificate?
Lordship, on that particular day, his brother's marriage ceremony was going on. There is a
plea of alibi that is to be established. And the standard of alibi, proving alibi is higher than other preponderance of probabilities. Standard of proving alibi is higher than the preponderance of probabilities for the accused. Yes, I don't find anything.
Yes, my lord, it is hard.
Proceed from this stage,
Yes,
beyond this stage. I am closing this. It is for you. Because otherwise, presumption, foundational fact, section 29 POXO, or it is not.
No,
76.
my lord.
64.
Yes, my lord. 64 2K.
64.
You have to stand in the trial, sir. It cannot be. Deaf and dumb. We are not interfering with. We are closing this, finding no merit at this stage to interfere in exercise. Heard Mr. L.R. Mojumdar, Land Council for the petitioner, and Mr. P. Sharma, Land Additional Public Prosecutor for the respondent state. Respondent number 1.
My lord, respondent number 1, my lord.
State of Assam, post of the instant criminal petition is preferred, invoking the inherent powers of this court under section 428 B and SS, seeking setting aside and quashing of criminal proceedings of Sessions Case T2 number 66 2025, which arose out of Guhaigaon Police Station case number 167 stroke 2024, ZR case number 187 stroke 2024, Search sheet number 162 stroke 2024, and search sheet. Full stop. In the first information report lodged before the officer in charge Guhaigaon Police Station on 11/10/2022, the informant had interiorly alleged that on 10/10/2024, the accused petition along with two other persons had committed forceful sexual assault on upon the deaf and dumb younger sister of the informant. Full stop. The FIR was registered for the offense under section 64 within bracket 2 within bracket K, small k, and section 70 within bracket 1, Bharatiya Nyaya Honhita BNS. Full stop. After investigation, the IO submitted a charge sheet under charge sheet bearing charge sheet number 162 on 31/12/2022, finding sufficient material and a prima facie case against the accused petitioner for the offences under section 64(2)(k, BNS. Full stop. On receipt of the charge sheet, the Committal Court of Planet Subdivisional Judicial Magistrate M. Guhaigaon issued process against the accused petitioner for his appearance before the said court on 15/5/2025, first of assailing the above, first of upon appearance of the petitioner before the committal court on 15/5/2025, the case was committed to the Court of Sessions. Full stop. It is the case of the petitioner that during the course of investigation, the alleged victim was medically examined on 11/10/2024, and as per the opinion of the medical officer, there was no mark of injury seen on the person of the alleged victim. Full stop. It is the further contention of the accused petitioner that on the date of the alleged incident, the petitioner was busy with the marriage ceremony of his sister, and as such, the occurrence of the alleged incident of forceful sexual assault was not possible. Post of It is from the materials on record, more particularly from the charge sheet, it can be noticed that the alleged victim, the statements of the alleged victim was recorded under section 183B and SS with the help of expert personnel. And the version of the alleged victim was found consistent with the case alleged in the affair. Full stop. According, as per the contents of the affair, the witnesses whose statements were recorded during the course of investigation also supported the version of the alleged victim. Full stop. Para. Mayor. An opinion of the medical expert is not the final word in a case of forceful sexual assault. Full stop. A plea of alibi is to be established by an accused in the course of the trial, and the standard of proving the plea of alibi, establish the plea of alibi, is higher than the standard of preponderance of probability. Full stop. In any view of the matter, the contention raised by the petitioner, accused petitioner, in the instant criminal petition can only be appreciated after recording of the evidence of the prosecution and after and full stop. In view of the aforesaid reasons, this court does not find any merit in the instant criminal petition. Full stop. Consequently, a criminal petition being devoid of merit, is not entertained. No cost.
Item 13.
Lordship, it is also a quashing petition. Lordship, in this case, allegation of sexual assault to a minor, Lordship.
Minor. POCSO.
Section 8 and 12 of POCSO.
8 and 12.
Lordship.
And Begum, yes.
Lordship passed by the Lord Additional District Magistrate.
Which one? Which order is impugned?
Lordship, Annexure 4, page 45.
Page 45.
45.
First party present, second party present, previous accused was seen that the case has been pending since so on the last that both party participants in the disputed land is purchased land of first party. Who is the first party?
Elisa Begum, I'm the first party, Lordship.
You are the first party.
I'm the first party there.
First land is purchased is a purchase land of first party and mutation position found in first party. Second party had no position. Mediation of this land. Also seen the police report. That party has tried to encroach the land of the first party. After her, the president feels the writing yes.
Lordship, the petition, vernacular petition, Lordship will find at page number 23, Lordship, filed by the respondent number 2.
Now you are the first party.
I'm the first party, Lordship. I'm the second party in the trial court.
Trial court, you are the second party. Yes. You had no position.
Lordship.
And mutation.
Lordship,
according to this report of police.
Lordship, kindly come to para 7 of my written statement, Lordship, page number 39. Para 7, Lordship. My husband name was mutated. My husband name, namely Habibur name, was in the Patta Lordship, Patta number 8 of that number 269 of village Tolbari Lordship. So after his demise Lordship, my and my daughter's name have been mutated Lordship. So this fact was brought to the notice of the landed court below, annexing the Jamabondi Lordship. Jamabondi Lordship, Annexer 5 Lordship, page 46.
As there in the it would be apparent the name of the second parties have been mutated. What is the concerned land? Let us see the let us see the first party's case.
Lordship. In that number 269, there are also 2 bigha, 4 kotha, and 16 lesser.
What is the first party's case? Where is the complaint?
On the vernacular Lordship, page 23.
Page 23.
Page 23.
What is the plot of land?
Schedule of the land.
What does it say?
Find page 25 Lordship.
Prothom Mohila.
Nalbari Jilar, Phokrapar Thana Elikar.
Which part? Which paragraph?
Page 25 Lordship.
25.
Top seal.
Top seal.
Top seal. Phokrapar Jilar, Nalbari Jilar, Phokrapar Thana Elikar, Posim Bunbhag Muzar, Balipara Gawar, Terasmedi, 8 number Pothar, 269 number Dagor, 1 kotha, Bigha Zomi, Chopta Kuriboliga Zomi Hoy. Lordship.
So it is not determining any right.
Lordship.
It is only the position.
The proceeding was not followed by the landed tribe court below. I was not allowed to adduce evidence, Lordship. Only on the basis of the petition and written statement submitted by me, the order was passed, impugn order was passed, Lordship.
But
and I was evicted from the settled possession, Lordship, which is not the scope of section 163, 165 of the BNS, Lordship.
Settled position, but here report is that
Lordship,
report of the police.
No circle report was called for. Lordship.
Police report. I also seen the police report.
Lordship, it is a settled law, settled by the Honorable Court, that the magistrate cannot proceed under section 163, 165 on the basis of a police report, Lordship.
On the basis of what then?
Police report.
On the basis of what?
On the basis of the pleadings of the parties, Lordship. And if there is a satisfaction that there is a apprehension of public peace, then magistrate.
Where it is law laid down that police report cannot be taken into.
This is the law laid down in the case of Makbul Hussain, Lordship. Consistently, this Honorable Court is. Para number 3, last part, Lordship. Last line, Lordship.
Para number 3.
Para number 3, last line, Lordship.
Last line.
Magistrate had no jurisdiction to entertain a proceeding under section 145.
Last line. Para number 3.
Para number 3, last line. Apart from this, Your Lordship, there is nothing in the petition that there is apprehension of public peace, Lordship. And this Honorable Court in this law, Lordship, in paragraph number 2, has categorically held that, Lordship, kindly have a look, para 2, Lordship.
No, as on that, what do you want?
Lordship, stay of the order dated 22/5, and notice may be issued to the respondent number 2. Because procedure also was not followed by the landed court below, Lordship.
What is your written statement?
Written statement. Lordship, Annexer 3, page 33.
Where have you stated that you have possession?
Paragraph number 7, Lordship. Page 39. It was apparently not considered, Lordship.
Then why the other party in the order, impugn order, it is recorded that the first party had the
Oh, apparently,
possession and mutation.
order is apparently perverse, Lordship.
No.
Nothing was considered, Lordship. No, I was not allowed to adduce evidence, Lordship. So procedural lapse is there.
Let us see the order says then. (2019, 2025).
Lordship.
First party submitted evidence.
No, Lordship, evidence not submitted. They have prayed in a on one occasion they have prayed to submit evidence, Lordship, before submission of written statement.
Is a police report part of the record?
No, Lordship.
Yes, Mr. Sharma.
My lord, order dated my lord 21/9, my lord. You must have also seen the police report submitted by in charge. That police report may be the part of the record, my lord.
Because here 125 it is only possession, nothing else.
Only possession, my lord.
Nothing else.
Nothing.
No right of the parties.
My lord.
For the right of the parties, it is a civil court.
My lord.
Lordship,
Nothing else.
Absolute, Lordship. In the case
Only
of
possession.
only in the case of causal withdrawal, Lordship is well aware that this honorable court has categorically held that if there is a threat of dispossession, party may file injunction suit, and there is a dispossession, party may file suit under specific relief act.
We'll call for the records.
That is my lord, and notice, my lord.
And Lordship, the impugn order may be stayed because
Then again there will be threat of disposition again.
I could not able to plow, Lordship, in order to cultivate.
How much is the area of land? 1 kabiha.
1 because, Lordship. So apparently, Lordship, procedure was also not followed, Lordship. So in that,
Let us see the records. We'll call for the records.
So interim may be granted till the next
We'll-
then your lordship.
No, that will be again another issue will crop up, multiple procedure proceeding.
Because
If it is to be set aside, set aside.
I have annexed all the orders, lordship.
We'll
So
put a,
procedure was not
from
followed.
which place?
Lordship.
From which place? Nalbari.
Nalbari.
Okay. Or will ratio requisition the record?
My lord.
Okay, heard Mr. GRM Mubarak, Learned Counsel for the
Mukhtarji,
petitioner, and Mr. B. Sharma, Learned Additional Public Prosecutor. Petitioners, huh? Response number 1, post up. The petitioner has a sale in order dated 22/05/2025. Passed by the response number.
No, ADM is not a party, lordship.
Huh? He is not a party.
ADM not a party.
Passed by the additional district. What is the impugn order?
Then except 4 lordship.
CH.
Page 45.
Additional district magistrate, Nalbari. Is there any case number? In case number 155, within brackets M, capital M, stroke 2024. So the proceedings of case number so and so was initiated under section what? BNS, I don't know.
160 to 165.
160
3 / 165 of the VNSS.
of the BNSS at the instance of the response number 2 herein as the first party poster. In the said proceeding, command of petitioners herein are the second party poster. The subject matter of dispute is a plot of land measuring 1 biga covered by block number 269 and pattern number 8 at village Balipara, Mouza Posim Bonbhag, Police Station, Khograpar District, Nalbari subject land. Full stop. By the impugn order, comma, it has been directed to the police to maintain peace and tranquility over the subject land and to take legal action against the second party, that is, the petitioners, comma, if they try to interfere with the position of the first party, full stop. Meaning thereby, comma, the additional district magistrate has observed that the position of the subject land is with the first party. And the first party also got the land, subject land mutated in her favor, full stop. Mr. Mubarak, Land Counsel for the petitioners has submitted that in the written statement, comma, the petitioners had clearly averred that the subject land is under their possession, and their names are also mutated in the revenue records as the owners by inheritance, but the said contention of the petitioners was never considered by the while in the proceedings, thereby making the impugn order dated 22/5/2025 as a perverse one. First of the matter would require consideration, issue notice, returnable on so and so date.
27/8.
As Mr. Sharma has appeared accepted for response number 1, formal notice dispensed with. the petitioner shall take steps for service of notice upon the respondents. From respond number 2 by start pursuit AG as well as by usual process within 2 working days from today. For the purpose of consideration of the contentions raised by the petitioners, the records of so-and-so case number are necessary. Post of registry to requisition the records of so-and-so from the Court of Land Additional District Magistrate, Nalbari. Post of having regard to the consent rate, it is observed that status quo as on date with respect to the subject land shall be maintained till the returnable date.
Supplementary list, item 43.
Yes.
Also, I am agreed by an order passed by.
What is 438?
Executive Minister, my lord, on 26/7/2025, Lordship will find that Annexure 7, page 29. My lord, this is a proceeding under 126 of BNSS. My lord, for keeping peace and security in the society, my lord. My lord, operative portion, Lordship will find that page number 31.
What is 126 BNSS?
It empowers, my lord, magistrate to execute a bond on it.
Yes.
Lordship may only also see section 130 of BNSS, my lord. My lord, if the magistrate is satisfied on 126, my lord, 130 says he has to give the details of the bond and how long it will continue, my lord. This is the order to be passed.
You say 130?
130 of BNSS. Order to be made, madam.
Yes.
My lord, here now Lordship will kindly turn to page number 31, my lord. Before that, my lord, before the impugned order, my lord, what happened? Notice was issued upon us. That
Let us
notice.
see the impugned order first.
My lord, page 29, it starts. Learned magistrate has narrated everything. I am.
What are the relations between the two parties?
My lord, they are cousins, my lord. They have inherited the same property. The complainant, they are in possession of the ground floor. She stays at a different place, but
Let me read. I cannot hear at the same
sorry,
time
my
while
lord.
reading this order.
Sorry.
I have no such separate chambers. You are the complainant there or opposite party there?
Opposite party in the.
How you are aggrieved?
My lord, I am aggrieved, my lord, by the page number 31, my lord, that second paragraph. That after foregoing discussion, the opposite party is directed to hand over one set of keys within 3 days from passing of this order to the complainant, and the complainant, after receiving the key, shall use either by herself or she shall be at liberty to let it be used by others without disturbing the peace and tranquility of the locality, and also the breach of security of the old age and mother of the opposite party, which is being apprehended by the opposite party, my lord. This direction, my lord, cannot be given by an executive magistrate, my lord, while proceeding under an 126 BNSS, my lord. My lord, he has decided who will use the key or not, my lord. My lord, our statement has not been recorded. Thing is that that particular person, my lord, who stays in the campus at night, he allows strangers in the campus.
Was it your statement before that
Yes,
court, page
yes, my lord.
30, last paragraph?
Yes, my lord.
On 19/6/2025.
I have given that. I have annexed at page 24, my lord.
On last page 30. Was it your person before that
Yes, my lord. That is on
forum that you were ready to hand over one set of keys to the complainant
to the complainant
on the condition that the complainant shall not be at liberty to give the key to any other person?
Yes, my lord. That is our problem.
Huh?
My lord, what
Was it
happened-
your version before the
Yes, my
forum?
lord. Yes.
Then how you are aggrieved?
My lord, agree because, my lord, the learned magistrate has said, after receiving the keys, she shall use either by herself or she shall be at liberty to let it be used by others without disturbing peace and. My lord, this particular person who stays there allows other person to stay overnight without any notice to the landowner, even to his owner also. So we installed a notice saying that gate will be closed at night 10:30 in the evening and it will be opened in the morning. There are 2 phone numbers given. He will call if in case of urgency it is required to be open. We have one house help, my lord. But he is disturbed with that because we keep notice on them. Whatever, my lord, but Laden magistrate who are acting under 126, my lord, from the provision it is very clear, he cannot go beyond that. On 19/6, my lord, we are asked to submit bonds. Both the parties executed bonds. There is no allegation that bonds were.
Because you have locked the premise.
No, my lord, not locked. We used to lock it in the evening only. We stay there in the premise. My lordship may kindly see. 24 is our written statement, paragraph 10. At 27.
It was a common property,
Yes,
joint
my lord.
property.
Common property.
Both these parties inherited the property. There is one gate perhaps.
Yes,
Huh? Who are you to lock for entire time?
my lord.
Who are you to lock?
At night hours, my lord, because that
gives rise to disturbance of peace and tranquility.
well, that will.
Unless you agree, it is very difficult.
My lord, what is our stand, my lord? Gate is locked and there is a notice given. 2 phone numbers are given of our help, my lord.
Is it the way?
Evening.
Is it the way?
My lord, otherwise, my lord, he will allow strangers to enter campus, my lord. And there is no say on the from
You
their
don't
land.
have the entire right of the over the property.
Yes, my lord. We don't deny, my lord, but whether my
But
lord,
giving no key to the other party is itself is a
but we
situation
have not
creating
denied, my lord.
disturbance in peace and tranquility. Your conduct is also not supportive of a situation removing disturbance in peace and tranquility. Because property is jointly inherited by both of you. One gate.
Yes. But my lord, under 126, my lord, if there is any allegation, that is different, my lord. But they have not approached appropriate forum.
Which party you are aggrieved?
My lord,
Which party were aggrieved?
by page 31, my lord.
One party is to hand over one sort of key.
Yes, my lord.
Are you agreed with that?
I am not. I can hand over.
One by one.
My lord.
One by one.
Yes, my lord.
Are you aggrieved by the direction to hand over one set of keys?
My lord, may I answer
We'll go
this
to
way,
the
my lord?
next part later on.
My lord, I can give, my lord, with a condition.
Okay. Within 3 days from passing that order,
Yes,
not aggrieved or aggrieved?
I can give, my lord.
To the complainant.
No problem.
No problem. Next, the complainant after receiving the key shall use either by herself.
By
Up to
herself,
that,
no problem. By herself is no problem.
yes. Whether the complainant has tenants there.
Yes, my lord. That's the problem.
Why?
No, my lord.
That's the problem.
The problem is.
That's the problem.
Problem is created by the tenant because he.
Well, you should notice, no interference.
My lord. He
No,
allowed.
no. You are trying to do something indirectly which cannot be done indirectly.
My lord, kindly consider my written statement, my lord. It is there on record. My lord,
Now
kindly
it has
consider-
come out. Cat has come out.
My lord, no, my lord.
Cat has come out.
My lord, the tenant will not allow stranger to stay in the revised act now, my lord. This is a college institute, not his residential house, my lord. This is a college going on there. He is a caretaker. He stays and he allows stranger to stay in the campus at night.
Well, you should notice, let the other party here replace the diagram of the building. I don't think.
But my lord,
Because
under
if she has the right to a part of the building, that includes the right to give it to a tenant. And if the locality is such that it is permissible to give it to a tenant to conduct a kind of business, there are many areas where some kind of business is not allowed. But that owner has the right to give it in tenancy. If that's the kind of tenancy is permissible under the law, right? Then it is not that you restrict. 24-hour access is there.
Oh my lord, I stand this, my lord.
It is tilting against you. Case is tilting against you
I am
now.
not restricting, my lord. I am not restricting. What I am saying, my lord, only this particular person, he allows strangers to enter in our campus, my lord, during night hours when my old mother stays only. She stays alone.
Whether both parts are separate or not.
Separate part, my lord. Only the entrance gate is same. Parts are separate.
Yes. Without disturbing the peace and tranquility. That order is there.
But, my lord, under 126, my lord, this order cannot be passed.
Okay, we'll examine that. What looking like everything is tilting against you now.
The date,
Heard
date is
Mr.
fixed,
T.O. Sarmala, Council Pada petition. Because law is not that. The law is equated, is to be considered with justice also.
But, my lord, the police cannot pass, executive magistrate cannot pass this order, my lord. Under
We'll see the legality and
But today is the
validity
date
of the order.
compliance, my lord. Some protection. Today is the date fixed for compliance. My lord,
We comply.
Page 31.
We are not satisfied.
37 fixed.
We are not satisfied with your conduct. And Mr. MP Gusami Larne, additional public prosecutor for the response number 1, 2, 3.
Only one, madam. No, madam, not also one.
Home Commissioner.
Actually,
Why
my
these
lord-
are parties?
Actually, my lord,
State of Assam.
Why these are parties?
in both, in 1 to 5,
They
also,
were-
we are not, I can,
4 and 5 private respondent.
because, my lord,
Who is this 4?
4 is the, my lord, complainant and 5 signed on behalf of 4, my lord.
Pinak Pani.
My lord, that FIR will cleanse, my lord, at page.
No,
20.
page 29. There are 2 names only.
My lord, kindly turn to page 21. The FIR signature, my lord. Down below, my lord, on behalf of.
Okay, 4 and 5. Okay. But what is? Why they are parties?
My lord, because state of Assam, my lord.
4 and 5.
Respondent number 3 is the
5 is the informant,
executive
my lord.
magistrate.
The authority who has passed. Okay, this
Respondent
man. Respond number 3. Okay. 1 and 2 required.
Perhaps not even, but they are the commissioner and secretary, so perhaps I cannot appear, my lord. They have to government
Let
advocate has to
government, my
appear.
lord.
Well, issue notice to 3.
Yes, ma'am, and also 1 and 2
On 1 and 2.
for GA government. Because
Subject matter of the challenge in this criminal revision petition. is an order dated 26/7/2025 passed by the respondent number 3 in case number 23/2025 under section 126, B and SS. First of all, the petitioner was the opposite party in the proceedings of case number 23/2025. First of by the impugn order, the opposite party was directed to hand over one set of keys, within 3 days from passing the order, to the complainant and the complainant, that is the respondent number 5. And the complainant, after receiving the key, shall use either by herself or would be at liberty to let it be used by others without disturbing the peace and tranquility of the locality, and also not to breach the security to the old age and mother of the opposite party. Full stop. The dispute arose out of a landed property located at GNB Road, Silpuguri, which is an inherited property for both the parties of case number 23/2025. Full stop. From the matters on record, it has emerged that the property, landed property, is shared by the families of the two contesting parties. Full stop. The matter would require further consideration. Full stop. The legality and validity of the order dated 6/7/2025 passed by the respondent number 3 in exercise of the powers conferred by section 126, B in SS has been questioned. The matter would require consideration. Issue notice returnable on so and so. That's all they did. You put it by Dosti to respond number 4 and 5.
13
To
August.
all, at this
13.
stage, this court deems it not proper to issue notice to the respond number 1 and 2. Full stop. Issue notice to the respond number 3, 4, and 5, returnable on so and so. The petitioner shall take steps for service of notice upon the respond number 3, 4, and 5 by registered procedurally as well as by usual process within 2 working days from today. In addition, Dosti, plead for so and so compliance affidavit on or before the returnable date.
13.
The having heard the land counsel for the petitioner and the factors which led to the passing of the order, this court is of the view that the prayer for interim relief will be considered, a request to be considered on the returnable date.
For admission, item 15.
May I please, your lordship? Lordship, my senior is engaged in another court number 2. Kindly pass over the matter for the day, your lordship.
What is the case?
Yeah, my lord. It's a case of my lord. 304A. Cognizance was taken under 304A.
304A.
My lord.
279.
Yes.
Gurisagar Police Station.
Yes.
Let us see the affair.
Lordship. Page 19, lordship. He is the driver of the vehicle who has caused the accident. That is page 19, lordship.
Road accident took place near Jhansi, Kothal, Business. Okay, Creta car. Then what happened?
Then, my lord,
Investigation
investigation done, my lord.
done. Search
And
sheet.
Search sheet was filed, my lord.
Where is that?
And search sheet is page 20.
Biswajit Mohanto.
Biswajit Mohanto, my lord.
These
Page-
are the listed witnesses.
Listed witness.
And good enough.
No.
Then if that is so,
No, sir.
then what is the ground for challenge?
My lord,
Sanjay Das.
yes. They say-
Medical report.
Yes.
Medical report.
Para
Why?
page 6, lordship.
Page 6.
Para 10, my lord.
Para 6, page 6, para 10.
He stated.
Oh, Ibsen Bats.
Yes.
Who is your senior? Call him. Ibsen Bats.
Yes, and from the witnesses, my lord, it is clear that he has.
Maybe that vehicle did not have any insurance. Now people resort to this kind of proceedings.
That part, I will not.
No, I know. What is the reason behind it?
No.
Okay, next.
Item 16.
What? Maintenance? This bench is always with maintenance, busy with maintenance or what?
Maintenance, my lord. Quite maintenance.
Huh? More than 50% is with maintenance only. Yes. Yes. 125.
Yes, my lord. 125.
Application under 125. Wife.
Wife will file this case, my lord.
Okay. 2006 marriage.
2006 marriage.
Both from Guwahati.
Both from, no, is both from Guwahati now.
You are living in where?
I am living in Guwahati, my lord.
Living in Guwahati.
Guwahati.
What job do you do?
I was MR.
MR.
Already.
Was.
I was.
You are 45 years of old. How you are living?
Now I am doing some business, petty business.
Huh?
I am doing some petty business now.
Petty business.
Yes, sir.
So in Guwahati 6,000 is enough.
But my income is very much poor, my lord.
You are disabled person?
No, not
Not disabled.
Not disabled.
How much a labor earns?
500, but
Not 500 nowadays. That is old.
5 to 6.
800.
6, 7.
8. Okay, let us assume he gets works for 20 days in a month. How much is that?
16,000.
What is your qualification?
BA.
BA.
Yes.
You are MR. So leaving MR means you have started good business. Leaving the job of MR and you have started a business means good business. Better than MR.
Not better.
Even a labor can earn 16,000 in Guwahati.
Yes, sir.
So MR is much more, 3 times at least. So why you are agreed? And they have a son also.
Yes, lots. Son is also.
And son is with?
Mother.
Mother. So you are aggrieved? Notice should be given why the amount should not be enhanced. Where is the order? Where is the order?
Order is page 13.
Okay, let us read.
Peshawar.
Let us read. What is the ground of challenge otherwise? Please tell me. What is the grounds of challenge in this case?
My lord, I was married in 2006.
Properly, did not properly appreciate the statement of the petition in his statements. What is the exact ground of challenge? What are the grounds of challenge in this case? Huh?
Still long for 15, 16 years is not with me.
No. What are the grounds of challenge? You were in revision, right?
Revision.
And what is the order passed? 6,000.
6,000.
Which part of the judgment?
Page 14, Lordship.
Who is the judgment? Who is the
Page 13, Annexure 1 is the order.
Annexure 1?
Page
Okay.
13 and 14.
What happened to 498A?
It was dismissed. I was acquitted.
Acquitted.
Acquitted on what ground?
That is at page 31.
So benefit of doubt, basically. Okay, let us read page 13.
Both the parties are present today is fixed for submission of written objection by the opposite party and hearing on interim maintenance. No written objection has been submitted by the opposite party against the interim maintenance. The opposite party has submitted written statement also. Pay the cost of 1,000. Let the same be given to the petitioner. The instant petition is instituted by the petitioner Srimati Madhuri Borua under section 125 CRPC 1973 against the opposite party, Pranjit Segia, claiming maintenance allowance along with the interim maintenance allowance for herself and her son. Had the both parties on fair or grant of interim maintenance allowed to her and her son. The petitioner stated that opposite party inflicted continuous mental and physical torture on her, for which she is compelled to live separately from the opposite party. It is stated that she is unable to maintain herself and her son, as the opposite party has failed to give any maintenance allowance to them till date. It is further stated that the opposite party is an area.
So it is your own version, 18,000.
With 20,000. My version.
18,000.
Yes.
Suppose in a case for motor vehicle compensation, the standard laid down is, Sarla Verma, is that a person spends 1/3 of his income
1/3 of income
for his expenses.
Yes.
The rest he spends for the benefit of his family members. That is normally, right?
Yes.
So 18,000, out of that 12,000 will remain with you. Only 6,000 will be to the wife and the son. How old is he?
He is in class 8.
At the time of filing the petition, he was 15 plus. Now he is just 17.
He is not yet major.
Yes, not yet.
Right? He will be major in September 2025. Thereafter, you make an application before the family court that he has become major. Reduce the amount, but we don't find as on date.
Yes, ma'am.
Mr. Deka, if you go to a school, is it possible in Guwahati? Heard Mr. I.C. Deka, Learned Counsel for the petitioner, and Mr. T.K. Mishra, Learned Additional Public Prosecutor for the, Learned Counsel for the respondent. Full stop. The invoking the revisional jurisdiction of this court under section 397, read with section 401, Code of Criminal Procedure 1973, the petitioner has preferred the instant revision petition to exile an order dated 10/8/2023 passed by the Court of the main proceeding is pending till
Pending, still
Yes.
lodged.
Passed by the Court of Learned Principal Judge Family Court number 2 Kamrup Metro at Guwahati. Post up. By the order dated 10/8/2023, the Learned Family Court has directed the petitioner, who is the opposite party in abstract criminal case number so and so, to pay an amount of rupees 6,000 per month to the respondent herein, that is the petitioner herein, as monthly maintenance. Full stop. The proceedings of FC so and so has been initiated on the basis of an application preferred by the respondent herein as the petitioner before the Learned Family Court under section 125 Code of Criminal Procedure, seeking maintenance amount from her husband, that is the petitioner herein. First of para. The marriage between the herein after packet or didigo. The petitioner, the marriage between the petitioner and the respondent was solemnized on 9/8/2006. And out of their wedlock, a child was born on 13/9/2007. Full stop. It was alleged. Oh, you have a second wife also?
Yes, yes, Lordship.
Huh?
It is her allegation.
Oh,
It is
great.
her allegation. But
Hmm.
together with a child,
Hmm.
new wife.
One more child.
Yes, Lordship. This is the allegation, not proof it.
The petitioner, the respondent, I realized that since the year 2007, the petitioner refused to maintain the petitioner and her son. Full stop. Para. The impugn order dated 10/8/2023 was passed on the prayer of the respondent to grant interim maintenance allowance to her and her son. Full stop. In the application under section 125 CRPC, the respondent had alleged that had asserted that the petitioner was working as an area sales manager in Alna Biotech H&L division and was earning a monthly salary of rupees 50,000. Full stop. In the proceedings before the Learned Family Court, during the hearing on interim maintenance, the respondent had reiterated the same as regards the income of the petitioner. Full stop. In response, the petitioner during the hearing stated that he was working as a sales representative, drawing an amount of rupees 18,000 per month as salary. Full stop. Para. Having regard to the above, statements of the parties made before the court and the Learned Family Court had reached an opinion that an amount of rupees 6,000 per month as interim maintenance would be just and reasonable for the petition respondent and her son. Full stop. Having, more particularly, comma, having regard to the monthly income of the petitioner. Having regard to the amount of rupees 18,000 as monthly income of the petitioner. Full stop. Having considered the matter from all standpoints, comma, this court does not find any merit to interfere with the order dated 10/8/2023 passed by the Learned Family Court, as the amount of rupees 6,000 to the respondent and her son and her son, who is pursuing education in Guwahati city, comma, is just and reasonable. Having found no merits, this criminal petition, revenge petition, stands dismissed. No question.
And his lordship most irregular in paying that maintenance amount also.
Issue distress warrant. Distress warrant. Get him arrested.
Oblige, Lord.
17.
Interim order doesn't recall. File of interim order doesn't.
May I please tell us? And in this case, my lord, in the year 2015.
NDPS. Cognizance.
Yes.
Against the petitioner.
Yes.
Good. Commercial.
Commercial. But
Intermediate or small?
commercial.
Commercial. Okay.
My lord, the facts.
Let us see the affair. You are Iqbal
Bahar Hussain.
Bahar Hussain.
FIR, my lord, page.
Let us see.
Page 13 is the FIR.
Due respect and harmony yesterday at about 10 a.m. on Jonathan informed me some intermediate line in a garage at Tila Bazar. The information I accompanied the BS of last because put up a opening a garage, found reloaded bags in an auto rickshaw. After opening these boxes, there no sidle bottles. These articles were seized in the presence of the required after a signature and signatures paid before the This was in 2015. Okay. Then
Thereafter, my lord, the police searching, my lord, two persons. The owner of the auto, Basir Ali, and owner of the garage, Masuddur Ali. Bashir Ahmed and Masuddur Ali. Both were granted.
owner of the garage.
Garage.
Ah.
Masuddur Ali. Both were granted bail by this honorable court.
That does matter.
Page
Yes.
17.
It was codeine.
Yes, my lord. 397.
Codeine.
Yes.
Right?
Why, my lord?
How much is the quantity?
397 numbers of bottles of cough syrup.
What is the codeine quantity?
Codeine, my lord, per bottle 10 mg. Per bottle 10 mg.
Per bottle?
10 mg.
10 mg. Total?
Total, my lord, 10 mg to 397 is not commercial quantity.
No, total.
397 into 10 mg, my lord. This is only.
No, whole bottle is to be.
Whole bottle?
Not 10 mg.
Then 100.
Is it so?
Then 100.
What does the law say?
Law now says, my lord, it was the case in 2015. My lord, I am not on that matter.
Law, when it is interpreted, it is retrospective.
My lord, why I am saying, my lord? This is
You are emboldened by what?
My lord,
Because of your
this is not the
anticipatory
case.
bail.
This is no, my lord. This is not the case here. I am, my lord, nowhere involved, not known about the incident.
We'll find out.
Yes, my lord.
We'll find out.
My lord.
We have not started yet.
My lord.
So what was the bail granted?
Bail granted by both Bashir.
Who are the petitioner there?
Bashir Ahmed and Musaddar.
Mosaddar.
Yes, annexure 2.
Mosaddar was granted bail.
Yes.
Why?
Yes.
Or was shown to be the petition. Oh.
And Bashir
Page 27. You have referred Musaddar Ali. Why Musaddar Ali was granted bail? Because Iqbal Bahar Hussain is the owner of the garage.
No. What happened?
Is it so?
This,
Is it so or wrong?
no, this is actually, my lord, that was a plea taken at the time of bail
Right.
application.
I can understand.
Yes, ma'am. That was a plea
Now
taken.
I am asking you,
Yes, ma'am.
are you the owner of the
I am
garage?
not the owner, my lord. Not the owner, nothing. The what happened, my lord? I would like to say, my lord, this is an open space, and then open space owned by my father. And this is an, my lord, auto is, my lord, standing in an open space near a market, my lord. This land is owned by my father. I was, my lord, 30 years old.
Let us see the charge sheet.
Yes, madam. Not a charge sheet, madam. Thereafter, my lord, Bashir Ahmed was granted bail, and police filed final report, madam.
Good.
Police filed final report.
Let us see.
My lord, kindly see page 20. Page 20 is the final report, madam. May I read, madam? The brief description of the final report is that SI Moni Sinha, son of Lala Sinha, IC Grisganj WP, lodged an FIR alleging inter alia that on 11/4/2015 at about 10 am, BSF Joan Janardhan, number so and so, informed that some intoxicated materials kept in a garage located at Tila Bazar. Accordingly, he along with staff visited the garage. 3 bales were found in an auto rickshaw bearing registration number so and so. On counting, it was found that 397 numbers of genocidal bottles, which were seized as per seizure memo before the BSF and local people, and God put the signature of the witnesses and prayed to take necessary action. The Honorable OC registered the case and handed over the charge of investigation to SI Moni Sinha. It is to be mentioned that apart from Moni Sinha, other IOs, namely SI H. Das, SI A.K. Malakar, SI M.A. Borbuya, after due investigation, failed to trace out the whereabouts of the main accused. After recording statements of the local witnesses, 397 numbers of genocide bottles were seized. For forensic test, the same was sent to Forensic Science, Guwahati, and collected the forensic report. The test was found positive as per FSL report. The auto owner Basiruddin and garage owner Musaddar Ali are implicated as per statement of the witnesses. The address of the driver of the auto rickshaw Sharifuddin was failed to trace out despite prompted effort was made out. There is no possibility of identification of accused in the near future. Hence, on getting no possibility of progress of future investigation, this final report is prepared and upon intimation of same to the CI cum OC submitted to the same to the SPK, and after getting approval from the SP Karimganj to submit the same to the court. Hence, this final report is submitted to the Honorable Court. This is the, my lord, findings in the final report. Here it is also the police referred that the garage owner is Musaddar Ali, auto owner Bashir Ahmed, and driver of the auto Sharifuddin. Now what happened, my lord? In the year 2020, Bashir Ahmed died, my lord. And in 2022, Musaddar Ali died. Both the accused person died. Thereafter, my lord, on filing final report, my lord, the kindly see, my lord, page.
Who died?
Both Bashir Ali and Bashir.
When?
Bashir Ahmed died on 14/7/2020. This is page 28, my lord.
2020.
2020.
And Musaddar Ali?
Musaddar Ali died in the year 2022. However,
22.
Specific date is not, I have not having the specific date. It is mentioned in the order. Page 28, my lord. Summons issued to accused Bashir Ahmed returned to service report stating that the said accused expired on 14/7/2020. Summons issued to Iqbal Bahar Hussain returned after service. Now, my lord, the Bashir Ahmed died in 2020. Thereafter, my lord, kindly see page 31. Page 30, my lord, kindly see page 30.
Okay, they died.
Both
No,
died.
case abated.
So both died.
Both died. Case abated. You were the only
No, my lord.
man standing.
I am not the owner. What happened, my lord? This The auto was
No, why the order of the learned session judge not accepting the final report by the IO is bad in law?
my lord, the learned
Come to page 27. LCR.
what happened, my lord? The notice issued to the informant.
We have
assignment.
seen. We have
Manish
seen.
Sinha has
It was in official capacity. That is why he was replaced by, because that man was discharged from service or retired from service.
even the
It
officer,
was the officer in charge.
the officer in charge also, my lord,
Ah.
have not before
In
the
a case of this, he is not a private person. That man was not filing the case in individual capacity. He was representing the state, right? So that man can be represented by the public prosecutor also. There no fault can be found. No fault can be found. Had it been Mr. H.R. Chaudhary, he filed a FIR for theft in his house, right? Then H.R. Chaudhary was not informed at the time of acceptance of the final report. Yes. But here, a police officer filed the FIR. And by the time final report was submitted, he was not in service. So he was sought to be replaced by the officer in charge. They are not prosecuting private case.
officer in charge also not examined.
Okay, public prosecutor himself, who is authorized to make submission, it is he who made the submission.
My,
That sufficient incriminating materials are available, so final report is not to be submitted.
my lord, my humble submission. Under what
We
basis-
are only on the point whether sufficient materials are available in the case record.
my lord, under what basis the prosecution can assume that
Now, what is your point? What is your point? Tell me.
during the
We will be limited to that.
my lord, during the course of investigation, nowhere it is found that I am the owner of the garage.
How do you know?
It is the police also saying that.
Now, how do you know?
Then why I have been
Have you seen the investigative materials?
in investigation? My name is not there, my lord.
Have you seen the investigative materials? Are you privy to the investigating materials?
My lord, even in the final report, police saying that owner of the garage is Masud.
So, H.R. Chaudhary, I am asking you, are you privy to the materials collected during the course of investigation?
No, I have. So far, my lord, the final report
The
is concerned.
opinion of the IO may not be the final word. Law has permitted the court either to accept the final report or not to accept the final report. It can direct further investigation also. Question is that, what is your point now? Tell me.
My humble
On what ground?
my lord, number first, my lord, it is a right, my lord, that officer in charge was not examined. Number one.
Okay, done.
And number two, my lord, during the course of investigation, my name was not come, my lord.
Okay,
in
done.
Sin, my lord. And third, my lord, I am not the owner of the garage.
Accepted.
There is no materials in this regard.
Okay, accepted.
So in the year 2015, I was only 30 years old. Boy.
So these are the three grounds.
So in the year
Okay, you have next birth certificate.
no, my lord.
Then on what ground you are saying?
Now 41 years, my lord.
2015, you are 15 years.
No, my lord, 30 years, my lord. 30 years.
So
My lord, at that time, my lord, my father was.
you are not ripe for committing a crime.
My lord, how I am not? I know.
So no, what is the case? In 2015, you were 30 years old. What is the case?
Case, my lord. This is an open space, my lord. Auto was lying in the open space. This space.
In the age of 30 years, I do not see any connect, sir.
Well, my submission that I have no connection with that offense, my lord.
Tell me that. But what is where the age comes until you are juvenile?
This is right, my lord. However, my lord, at the age of
30 years,
I was
We
not,
find hardened criminals also, right? Committing almost already 50 crimes. We find hardened criminals at 30 years.
Yes.
One may be innocent also. Let us come to the core point. 3 points you have urged. One is OC. Second, that
during the course of
FIR were not named, and during the course of investigation, nothing came out against you. And third?
and third, my lord, I am not the owner of the garage.
Okay. And what is the stage of the proceeding?
Yes, my
Are you
lord.
enjoying any stay order?
I'm in bail, my lord. No, stay order was not granted. It was saying the stay order.
So are you not still appearing?
Appearing? Still
What
appearing.
is the stage of the trial?
Trial, my lord, as my main, both the accused persons have died, my lord. So only I am appearing, my lord, day after day. Nothing was progressed back. As because, my lord, in this case, anything, my lord, remains. How I can be grasped in this case, my lord? Because, my lord, I am not the owner of the garage also.
Mr. Chaudhary, you should make submission in the proper line. OCI, okay, this can be a right. Mr. Goswami,
Lordship, Lordship.
you have marked this?
Yes,
Or
Your Lordship. Yes, my lord. Your Lordship may kindly.
Okay, okay. Otherwise,
Yeah.
my power will go up.
Yes, relevant. No, Lordship, Lordship.
Otherwise,
Yes, yes. Because it's very. Lordship may kindly see the English language, my lord. It's last year, Lordship will find the IO report, my lord. That will perhaps.
very difficult. What is his name? Iqbal Basar
Iqbal
Hussain.
Bahar Hussain.
Witnesses are hard to read. Anyway. And my lord, Lordship can see the last flag where the IO gives ending line.
It is difficult to read.
Yes. But your Lordship can find and the last flag, your Lordship may kindly see that will, my lord, clear up the case, my lord.
Last flag.
Last Lordship. IO's remark, my lord, I have stated.
These are orders. Could not understand ABCD of it.
No, see, as per the my lord, what I have found, my lord, that he is the owner of the garage.
Ah.
He and his father, my lord, is
Looks
the
like.
owner of the garage, and they used to, my lord, give not on rent or purpose, my lord, to stay the vehicles, my lord, of other vehicles to access to their compound, my lord. In this way, that vehicle is in their compound, my lord. And interestingly, my that vehicle was, my lord, it was off road for some months, my lord, before the incident, my lord. So in that way, my lord, suspicion is over this person, my lord.
But it is difficult to read all this.
Yes, man. Somehow I could manage.
Masadar Ali.
One part is English, my lord. May I point out that part?
Please. If you are the garage owner, just for a situation, 397 bottles containing codeine in an auto rickshaw was found inside your garage.
Inside the auto, my.
And inside the auto, there used to be a house. Inside the house, there is a room. Thereafter, there is a mosquito net. And inside the mosquito net, there is a man. Right? So, there was a garage. Inside the garage, an auto rickshaw. Inside that auto rickshaw, 397 bottles of codeine. Right? And that auto rickshaw was there for some time.
This garage, my lord, in fact, my lord, is an open space nearby a road.
We don't know.
This is auto rickshaw garage, my lord, is not like the house.
Because
or something, but
we have
general-
to see regarding possession or dominion. Possession or dominion.
My lord, what happened in
Had it been found in judge's field, okay. But it is a private property. Inside a private property, there was an auto rickshaw. Without your permission, the auto rickshaw cannot be there. Right? And if the auto rickshaw is there, then dominion is of you, of the auto rickshaw. Right? And inside that auto rickshaw, 397, not single or 1 to 10 bottles. 397 cannot escape notice of a person.
397, if we accumulate in a particular area, it's that amount.
I have not seen, but bottles mean, I think at least minimum this size.
That can be kept in the inside of an auto.
Okay.
That cannot be.
Who else then? Who will take the auto inside your premises, garage, and kept it for some time, some days? Proceedings abated against the other two who expired. You are the lone man standing now.
The garage was being controlled by Mosaddar Ali. I am the, my lord.
That we cannot say.
Then the land where the garage is.
People have said.
When the land where the garage is situated, this land is owned by my father, my lord. This is the only implication. Mosaddar Ali was controlled my lord, managing this garage, my lord. This is the police saying, my lord. Witnesses is saying, my lord. Bashir Ahmad is the owner of the auto.
Mr. Chaudhary,
Sharif
how can you know about witnesses? The exact question I asked you. How can you know about witnesses since you did not appear as on date? Have you got? Did you appear before the court?
Appeared,
Yes.
appeared.
Where which witness said so? Tell me, it will make our task easier.
My lord, say,
Which witness?
I appeared, my lord, for some days, for the last some days. but making transparent, nothing is, my lord. What will happen in this trial, my lord?
No, trial, see, three accused, two expired. The trial will abate against them. But that does not mean the trial will abate against you also. That is not a law. Hmm.
The statement of my lord,
Where the seizure?
seizure is there, man.
Seized 297 so and so from auto rickshaw number so and so from the garage.
Yes.
From a garage. Recorded the statement 161. Seizure. Hundred ml. 100 ml means
This one, ma'am.
how much? No.
100 ml, that one. 100 ml bottle.
Cannot go unnoticed. 397 bottles. How much it will be?
No, my lord. 397 was not like that. But it will come in this later one.
Hundred. Mahindra auto rickshaw. Seizure following. Oh, where is the Mr. Goswami? Please mark the seizure list.
Seizure list.
Owner, it has emerged.
Yes.
He is the owner of the
Yes.
garage.
See,
Statements are there. Initially thought that
yes.
they,
Father is the owner, my lord.
Initially, I thought there others are the owner.
My
Later on,
father,
after
whatever my
you
father
prove
is
it
the-
before the father that father had the position. So that your father can be roped in under section 319.
This is some, my father is the owner and it is managed by the Mosaddar Ali. I am not there, my lord. Sometimes being a son, my
That
lord,
is not emerging from.
being a son, my lord,
Show me it has emerged from materials.
my lord, I may be allowed to go through these documents. This-
It was available all throughout. Now you have made me to look at it. Why should I keep it pending now? It was available. Causley was showing it.
My lord, earlier,
Scan copy is available.
earlier, my lord, it was not come, my lord, case diary.
left side,
It was, my lord.
the left side.
Today we have taken up the matter at 3 o'clock or 3:30.
In the left side.
Left. 100 ml Zenocidal. Moni Sinha. Loaded in a Mahindra auto rickshaw. Mahindra has auto rickshaw also?
Yes.
Okay. This is in connection with so and so.
Auto is also there.
Basir Ahmed. Auto was also seized.
Yes, there is there.
Auto was also seized.
Auto.
Basir Ahmed was the owner.
Yes, madam.
And it was kept, used to be kept.
In the premises of these petitioners. But so far the statement of my lord, Musaddar and Wasir, my lord, it was off-road for some months, my lord.
Off-road for months.
Yeah, that is.
Basir Ahmed.
Yes. Lawsuit.
Basir Ahmed. Okay. Well,
There is also a bail order of my lord, Musaddar, my lord, where it is been specifically held by the Honorable my lord, High Court, my lord, that Iqbal Bahar Hussain is the owner of the garage. going for the CD.
This man also says Abdul Salam. Amar naam ঠিকানা আমি এলাকার বাসিন্দা ওই রিক্সা ওই গাড়ির চিনি উক্ত গাড়িখানা তিনি প্রতিবেশী ইকবাল বাসার হুসেইনের গ্যারেজে রাখিতেন। Who is your father? Mr. Ali গ্যারেজের মালিক নয়।
No.
My father Abdul Noor, my lord.
Abdul Noor.
Noor name is also there.
মালিক Abdul Noor আর গ্যারেজ চালাইতেন ইকবাল বাসির আহমেদ।
Being a son, my lord, they are saying.
These are Basir, Iqbal Bahar. Some are illegible, but question has the things have emerged that
Thing has emerged.
you are the owner of the garage.
No.
Inside the garage, the Mahindra auto rickshaw. Inside the Mahindra auto rickshaw, 397 bottles of 100 ml containing codeine. Codeine FSL report is there
It is
or not there. If it is not there, gone. FSL report is there. Where is the bail order? And next.
one bail order doesn't. Bail order doesn't.
Somewhere it is there.
Yes.
In the court orders, it perhaps.
Yes.
And bail order is there.
Bail order. What is a part of the charge sheet? If it is FSL, it is okay. Yes, Mr. Suri, is it mentioned or not?
Page 17, Lordship, in the petition also, my lord.
Page 17.
In the petition, my lord. Lordship.
So it is there.
Yes, Mr.
Positive.
Positive, my lord.
Codeine.
Codeine.
And the IR report also.
Yes.
Submissioner report. Yes, sir. No point keeping it pending.
My lord, my humble submission, my lord.
Let the truth emerge.
My lord, some time may be granted, my lord.
I have spent already.
My lord, some time may
I have
be
spent enough time going through with.
One day, my lord, time is granted. For any other date, I will file some citation, my lord. Along with
No citation. You cited before the higher court.
We'll
Heard
to this
Mr.
record.
H.R. Soduri, Land Council for the petition. And Mr. MP Goswami Learned, additional public prosecutor for the respondent number 1, State of Assam. the instant criminal petition is preferred, seeking to invoke the inherent powers of this court under section 482, read with section 401 of the Criminal Procedure Code 1973, the CRPC or the code in short, for short, for setting aside of the setting aside of the proceedings of special within bracket NDPS case number 05/2015, presently pending before the Court of Learned Sessions Judge Karimganj, including the order dated 2/7/2022, taking cognizance for the offenses under sections 22 within bracket small c stroke 29, Narcotic Drugs and Psychotropic Substances Act 1985. Full stop. By the order dated 2/7/2022, the learned special court no? After taking cognizance of the aforestated offenses, issued process against the three cited accused persons: 1. Mosaddar Ali, 2. Basir Hussain, and 3. Iqbal Bahar Hussain, within bracket the petitioner, to appear in the proceedings of special NDPS case number so and so. Full stop. It is stated in the bar that in the meantime, the two charge-sheeted accused persons namely Mosaddar Ali and Basir Ahmed.
These are not charge sheeted, man.
Huh?
Not charge sheeted. Final report was filed.
Okay.
Charge sheeted.
Oh, charge-sheeted নহয়. Charge-sheeted to guchabo. The two accused persons namely, Mosaddar Ali and Basir Ahmed have expired. Full stop. The learned special court in order by order dated 29/4/2023, observing that Basir Hussain had expired on 9/9/2022, had held that the case against him stood abated. Full stop.
Basir Ahmed died 14/7/2020. Page 28.
Page 32. Bahar Hussain. Sorry.
Page 32.
Oh, Mosaddar Ali. I'm sorry. Mosaddar Ali. And what is that?
Basir Ahmed died
Page
28, man.
28. I can only repeat. Order dated 2/8/2022. This is Basir Ahmed. Date is 14/7/2020. Stood abated. as a result of abatement of the case against the two other accused persons, it is the petitioner who is to face the proceedings of special case number so and so, who is the sole remaining accused to face the proceedings of so and so. It পিছত লিখিব and with the instant criminal petition, the orders passed by the learned special court during the period from 28/1/2022 to 22/12/2023 are found annexed. Full stop. It is noticed that summons was issued to the petitioner pursuant to the order dated 2/7/2022. And the petitioner is yet to enter appearance in person before the learned special court till date. Full stop. এইটো পিছত লিখিব ৰাখি থক the case was the special case, the case special case number so and so arose out of which police station? Karimganj police station, case number 285/2015. Post of the affair was lodged by a sub-inspector of police attached sub-inspector of police who was the then in charge, Girisganj outpost. Also, in the affair, which was in reference to Girisganj outpost, GD entry number 134 dated 11/4/2015, the informant had interiorly alleged that on receipt of information regarding keeping of suspected articles in a garage at Tilak Bajar area, a team of police personnel along with BSF personnel rushed to the place, and after opening the garage, an auto rickshaw bearing registration number AS-10/C-4224 was found, having on a charge being made inside the auto rickshaw, 397 numbers of xenosedyl bottles were found to be kept illegally, and the bottles were accordingly seized by the seizure list by preparing a seizure list in presence of witnesses. No names though the name of any person involved in keeping the 397 bottles of xenosedyl was mentioned in the affair, the investigation was carried out, and the IO of the case had on 39/2019 submitted a final report stating inter alia that there was no possibility of identification of the accused in the near future. Full stop. The IO had observed that as per the forensic test report, comma, the test was positive. Post of the auto owner Basir Uddin and the garage owner Mashaddar Ali were implicated as per the statement of the witnesses. Full stop. When the final report was submitted before the learned special court, comma, the learned public prosecutor had submitted that if the materials in the case diaries were produced, comma, considerable incriminating materials were found, full stop, would be found, full stop. Notice was thereafter sent to the officer in charge, Karimganj Police Station, for a hearing on the final report submitted by the IO, full stop. The officer in charge, Karimganj Police Station, despite being summoned, did not appear before the learned special court. Full stop. The learned public prosecutor had moved a petition, petition number so and so, petition before the learned special court for taking cognizance of the offences under sections 22C/29, NDPS Act against the owners of the auto rickshaw and the owner of the garages, Masaddar Ali, Basir Ahmed, Iqbal Bahar Hussain, stating inter alia that Basir Ahmed was the owner of the auto rickshaw and the countable articles were seized from the garage of Masaddar Ali, which was allegedly owned by Iqbal Bahar Hussain. After perusal of the materials in the case record and the final report, the learned special court took cognizance on the final report and against the three persons, Basir Ahmed, Masaddar Ali, Iqbal Bahar Hussain. By order dated 2/7/2022, processes were issued against the said three accused persons. Mr. Choudhury Learned Counsel, appearing for the petitioner, has submitted that the Learned Special Court could not have taken cognizance on the final report for the offences mentioned therein without appearance and hearing of the informant stroke the officer in charge, Karimganj Police Station. He has further contended what?
During the course of investigation.
During the course of investigation,
I was not found as an owner of the garage.
There was no materials were found, no incriminating materials were found against the petitioner.
Also, I am not the owner of.
And the petitioner is not the owner of the garage. Insofar as the first contention raised by Mr. Choudhury is concerned, it is pertinent to mention that the FIR was lodged by a sub-inspector of police who was the then in charge Girisganj outpost within the territorial jurisdiction of Karimganj Police Station. The FIR was not submitted by the informant in his personal capacity, but the FIR was submitted by the informant in his official capacity. Post of the offense alleged in the FIR was in respect of contraband substances possession of which is illegal under the provisions of the NDPS Act 1985. Full stop. Notice to the informant was sent by the Learned Special Court when it considered the final report submitted by him. But notice to the informant sub-inspector returned answer with a report that the informant sub-inspector had already retired from service. In view of such, at that stage, the Learned Special Court, having received such information, the Learned Special Court issued notice to the officer in charge, Karimganj Police Station, for hearing on the final report and to receive to hear him on the final report, and as regards the submission made by the learned public prosecutor for taking cognizance on the final report on the basis of the materials, incriminating materials available in the final report, by not accepting the final report. But the officer in charge, Karimganj Police Station, who was summoned to appear for hearing, did not appear before the Learned Special Court, nor did he submit any report. Full stop. It was in such situation, the Learned Special Court had proceeded not to accept the final report in view of the sufficient incriminating materials, available in the final report, available with the final report. Full stop. In a case instituted on the basis of an affair lodged in the official capacity, we do not find, this court does not find any merit in the contention of the learned, contention advanced by the learned counsel for the petitioner. Post of the Learned Special Court cannot be said to have the authority, power, authority, and jurisdiction to take cognizance, to take, not to accept the final report when the informant, police officer who lost the affair in his official capacity, did not appear before the learned court despite notice. Full stop. In other words, the Learned Special Court was well within its power, authority, and jurisdiction to take notice of the incriminating materials available in the materials available with the final report. And having been satisfied that the final report is not to be accepted, comma, it can very well take cognizance of the offenses made out from the incriminating materials available and thereafter to issue process against the accused persons. Post para. Second to key question. What is your second submission? Yes. The incriminating materials, sorry. Yes, where from you know that no incriminating materials? Where from you have not appeared before the court?
I have not appeared, my lord.
You have not appeared. So 207 stage
Police also
was not there.
Police
So
have
where from?
Police
You are
have-
privy from where?
my, during the course of investigation, police
This
have,
is also an interesting thing.
police have not searched me, my lord.
That is
Police never searched me, my lord.
also no material. The provisions of section 207 CRPC has provided for supply to the accused a copy of the police report and other documents. Full stop. In a case where the proceedings has been instituted on a police report, the magistrate shall have to furnish the copies of the following 1, 2, 3, 4, 5. The petitioner to whom summons were issued as far back as on 2/7/2022, has not yet appeared before the learned special court so as to get the copies in terms of the procedure, in terms of the provisions set forth in section 207 CRPC. Full stop. Therefore, the contention advanced by the learned counsel for the petitioner that there are no incriminating materials against the petitioner does not hold. Cannot be said to have any force because for the reason that the materials available collected during the course of an accused person cannot be privy to the materials collected during the course of the investigation and available in the case diary. Post stop. Para. Having gone through the materials of the case record, it is and the statements of the witnesses recorded under section 161 CRPC, it is noticed that few witnesses have stated that it is the petitioner who is the owner of the garage where the auto rickshaw bearing registration number so and so was found. Full stop. It is the materials are suggestive of the fact that the said auto rickshaw was kept in the garage of the petitioner for a substantial period of time by the owner of the auto rickshaw, who was known to him, who was well known to him. It was inside the said auto rickshaw, 397 bottles of Zelosite so and so of 100 ml were found. On examination, by the forensic science laboratory, the bottles were found to have contained codeine. Post from the quantity recovered and seized, it has clearly emerged that the quantity is a commercial quantity under the NDPS Act. Full stop. In a proceeding, in a petition under section 482 CRPC, the veracity, acceptability of the materials cannot be gone into, as it is a matter of appreciation or during the course of the trial. Full stop. The materials, if the materials, full stop. For the aforestated region, this court does not find any reason to enter in the instant criminal revision or criminal petition. There is no merit is found to exercise. There is no reason. This court finds no reason to exercise the inherent powers of this court under Article or Section 482 CRPC. As such, power is to be exercised only in exceptional cases where there is no materials, incriminating materials against an accused, like the petitioner in the case. The criminal petition being unmerited stands dismissed. No order has to pass.
Nice.
E15. It will go next to job. But parallel or not.
Item 18.
May I please, Your Lordship? In this case, my lord, the client has engaged senior counsel, Mr. James Odris, sir, my lord. Kindly pass over for the day.
In this case, my lord, seat has been laid down.
Okay, on the prayer of Mr.
SK Jain, my lord.
SK Jain, learning counsel for the petition. Leaves the case after a week. Mr. MP Goswami, learned additional public prosecutor, is in attendance. And Mr. A. Ganguly, learned counsel for the respondent number 2 are present.
Obliging.
Item 19.
Yes. 320 CRPC.
Yes, madam.
Compromise. Offense 440-17. It can be done.
Non-appeals, madam.
No point keeping in pending. But there is no representation on behalf of the petitioner today on call. Mr. MP Goswami, learned additional public prosecutor for the respondent state, is in attendance. In view of such a non-representative, is the case on so it can be closed.
Closed.
No point.
11 others. Item 21.
Ganesh Sohan. Application filed suspension protection of comment from the Yes.
I am APM for the respondent number 2, my lord. And persons of the order, my lord, they have stated that we are trying to compromise this.
You want to
matter, my lord.
compromise?
No, my lord. They have till today, my lord. They have not a single phone has been called, my lord, to the respondent number 2, my lord.
We can put it on in mediation.
Lord,
Yes, Lordship.
I am ready, my lord.
Hey, order, no. Process is going on now.
Lordship.
Nationwide mission. DB case.
DB case, lordship.
Yes, madam.
Yes, Lordship.
I heard Miss
B. Hajarika,
P. Hazarika, learned counsel for the
petitioner.
petitioners. Mr. M. B. Goswami, learned additional public prosecutor for respondent number 1, comma, state of Assam, and Mr.
A. Mubarak.
A. Mubarak, learned counsel for the respondent number 2. Full stop. The respondent number 2, as the agreed person,
Lordship.
has instituted the proceedings of DB case number
65/2024.
DB case number 65/2024 before the Court of Learned Judicial Magistrate First Class Nalbari against the respondents, comma, who are the petitioners herein, right? So stop. The learned counsel for the parties have submitted that having regard to the nature of disputes, comma, there is an element of settlement through mediation. Full stop. Presently, comma, the special mediation drive, comma, mediation for the nation is going on. Full stop. Para. Having regard to the issues involved, comma, this court is of the primacy view that there exists an element of settlement. Full stop. Para. The standard operating procedure permits the willing parties to permits the mediation process to permits the mediation process either in offline mode, physical mode, online mode, or in hybrid mode. Full stop. As agreed to by the learned counsel for the parties, comma, the first date of mediation is therefore fixed on.
Any day after 15 August, my lord.
Okay, 16 August. Holiday. 18 August. For the purpose of further reference, the parties shall contact the coordinator stroke nodal officer of the mediation center, Mr. So-and-so, mobile number so-and-so, email ID so-and-so. Comma, list the case. After the conclusion of the mediation process with a report. Try or it may be settled.
23. May it please your lordship. Lordship, this revision, lordship, challenging the order passed by the special judge, lordship, Vishwanath, regarding Jimma, rejecting the Jimma of the petitioner, lordship, is the register owner. That order, lordship, will find on page 31, lordship.
Yes, Mr.
Here we have found a report, my lord, that the case has been surseated, my lord.
But he is not the accused in this case.
And he is a surseated accused. Do you
Now-
have the copy of the surseat?
Yes, lordship.
Do you have the copy of the surseat?
No, lordship, I have an instruction, there's lordship.
Can you get the instruction who are the persons surseated?
Yes, I will get the instruction, my lord. But
On 6th.
6.
6th, no? 6th. No? No? Oh, it will. 6th. 6th of August.
Even then, lordship, nothing was recovered from this vehicle, lordship. That's true.
We have put all these kind of cases on 6th. That is why I have inquired. Right?
Yes.
Vehicle seized in connection with NDPS case.
Yes.
Right? B. Chaudhary, MP Goswami. Mr. Learned counsel for the parties have submitted that after investigation, comma, the IO has already submitted a surseat, comma, post Mr. Goswami, learned additional public prosecutor has submitted that he will obtain the necessary details as regards the persons who have been surseated in connection with Behali Police Station case number 12/2025. Post of as sought for and agreed to by the parties, list the case on 6th.
Obliged, sir.
Huh? Meeting. Okay.
Item 24.
Immediately. Lordship. Lordship, this is in criminal. appeal.
Yes, this is the first time.
Yes, Lordship.
What is the period?
Lordship, 2 years.
2 years.
Conviction 2 years, 2 years, and 1 year. On 3 counts, 354, 325, and 324. Initially, it was a POXO case, but the POXO offences and the 376 are not proved.
354.
Yes.
2 years.
Yes.
Then
325.
325.
2 years.
2 years.
At 324.
2 years. Concurrently.
Yes, concurrently. Lord.
And you were allowed bail by the.
Yes. Yes, Lord.
Huh?
Yes, Lord.
By the land trial court.
Yes, Lord.
Okay, the trial court was which court? Special court.
Special Judge Morigao.
Special court. Yes, Mr.
Admitted, my lord. Matter may be
And about
admitted and
I
LCR may be called. I, my lord, he is already, my lord, on bail.
on bail.
Maybe
No, we can exercise the power under 2 years, below 3 years.
2 years, yes, my lord. That
It is concurrent.
Yes, my lord.
Okay, heard Mr. D. Ullah, learned counsel for the appellant. And Mr. R.J. Borua, learned additional public prosecutor for the respondent. Number 1, State of Assam. Nothing of POXO?
No, nothing.
Okay. On this criminal appeal under section 4152, BNSS is directed against a judgment dated judgment and order dated 11/6/2025 passed by the Court of Learned Additional Session Judge cum Special Judge within bracket POXO Morigao in POXO case number 16 of 2019, which arose out of Morigao Police Station case number 643/2018. By the judgment and order dated so and so, the appellant has been convicted for the offences under section 354, section 325 and section 324 of the Indian Penal Code, full stop. For the offence under section 354 IPC, the appellant has been sentenced to undergo rigorous imprisonment for 2 years and to pay a fine of rupees 3,000, with default stipulation, full stop. For the offence under section 35, same rigorous imprisonment 2 years, 5,000 fine, default stipulation. For 24, 1 year, rigorous imprisonment, no fine. The sentences are ordered to run concurrently. Stop. Oh, I have gone through the contents of the memorandum of appeal. Full stop. The criminal appeal is admitted for hearing. The case records of special case, POXO case number 16 of 2019 be called for. Issue notice returnable in 4 weeks as Mr. Burwal and additional public prosecutor has appeared so and so. Extra copy within 3 working days. The petitioner shall, the appellant shall take steps for service of notice upon the respondent number 2 by registered post with AD as well as by usual process within 3 working days. Heard Mr. D. Ullah, learned counsel for the applicant appellant, and Mr. R.J. Borua, so and so, opposite party respondent number 1, State of Assam. The applicant as the appellant has preferred the connected criminal appeal, criminal appeal number so and so. We can look at the Mr. Ullah, learned counsel for the appellant has submitted that the petitioner has been allowed to remain. What is the equivalent of section 389 in BNSS?
430.
430.
Yes.
Subsection?
That's it. 430, yes. Has been allowed to remain on previous bail. No, face bail.
Allowed to?
Allowed to go on face bail, and we have already submitted bail.
Okay, allowed to go on face bail. by the learned special court in terms of the provisions of subsection 3 of section 430 BNSS. Full stop. Having considered the period of sentences passed against the applicant appellant, comma, which are ordered to run concurrently, comma, and upon perusal, upon primacy perusal, upon perusal of the materials on record, comma, this court is of the considered view that yes, he has to go on fresh bail or previous bail.
Let him even previous bill.
Okay. Okay.
Now previous.
This court is of the considered view that as the connected criminal appeal has already been admitted, comma,
The sentence, man.
huh? The suspension, it is ordered that till the disposal of the appeal, comma, the sentences passed against the applicant appellant shall remain suspended and the applicant appellant shall remain on previous bail on bail as already allowed by the learned special court. What is this appeal? Who is this? Who is the appellant in item 25? Huh? What is the period?
Period is 3 years, 2 years.
Okay. Friday video, no, Friday video. 25 Friday. I have a meeting actually. And anything?
27 million, 5 years.
Merit. On merit. Merit case 20? Which one?
27.
Okay, AM Ahmed to Monday.
Item number 44. Appeal is
44.
44 and 45 and 10 matters.
These are
Lordship, in this case, I am appearing as an additional special public prosecutor in
which
APSC
one?
cases.
Oh, I am not taking up those.
In the Bhangagad PS case,
No, all these appeals are not by me.
Date may be fixed.
This appeal before events without me, any other events without me. 44, 45.
44,
Lordship, in item 26, it's a fresh appeal.
86.
26.
26. Did you have Friday or Monday?
Lordship,
Did you?
item number 28. says
28.
Jimma matter, same NDPS case, 6th of August, your lordship, as the lordship.
Okay, has sought for by Mr.
D. Bora,
For which item?
28.
28.
6th of August.
6th of August.
Item number 39.
For what? I.
Bail.
Bail.
Yes, kindly next week.
Let us find out. Court master will give it. To bail or item number so on. 39 to the bail or
Item number
41, Lordship. Criminal revision petition with IF for condonation of delay, 81 days, Lordship.
Condonation of delay.
Last week.
Lordship, item number 38, Lordship, may be fixed next week, Lordship.
Next week is bit tight.
Lordship, because DB matter, they have.
Next week is a bit
health
tight.
and State, Lordship.
I must say, may not be possible if it is gone down the list. Thereafter, I'll be free.
Lordship, a date may be fixed up.
LDB.
Lordship,
LDB.
item number 42, Lordship.
Yes.
I is there, Lordship, for NBW issued, Lordship, urgency.
DD was hyperlink. Fixed for you.
Give all this.